Yeah, Mr. Simpson, Alex.
That's kind of quiet.
Usually just Alex Simpson. I just sent him it this morning, so he should be on. Well, I'm not gonna be a part of this, so. I forget which position he took. Oh, he took Brasher. Oh. Right, so I guess it just depends on when Brasher was last elected. I don't know. Plus, I don't reside in Fulton, so. Thanks.
Gonna have to slide down. I need everybody to take a slide over. Take a slide over. Everybody slide over. Take it rolling back. All right, the Superior Court of County Judicial Circuit is now in session. The Honorable Judge Charles M. Eaton Jr. is presiding. Court will now come to order.
Please be seated. Morning.
You can get 'em in before.
Okay, well, good morning, everyone. So we've got a big calendar and I will go through it and take announcements on the final plea here. So let's start with, looks like position 1 and 2. Robert Riley.
Mr. Riley is present, Your Honor. I'm listed as the attorney of record. Actually, Mr. Scott King is counsel.
Okay.
Your Honor, 88 Clark for the state.
One minute, Ms. Clark. I'm still getting some background information from Ms. Robinson. Go ahead. The combined entry of appearance and notice of conflict are always great ones to get. But go ahead, Ms. Clark.
Okay, Your Honor, yeah, so I'm sure Ms. Robinson may have already updated you on, but on this case, it appears that attorney Scott King has entered an entry of appearance. And yesterday, I think a leave of absence or conflict was filed. Just to let you know, the state has served discovery in this case. And an offer was previously given to PD Clark However, that same offer will be extended to Attorney Scott King. On position 2, that will be 88 Iqbal's case. As you know, she's in trial, so I will be making her announcements on her behalf on that case. So she will be handling that case. An offer has been extended on that case as well.
Give me one more minute on this one. Yeah, leave it on the trial calendar for now. Position 3, Antonio Lewis.
Is Mr. Riley excused, Your Honor? This is not my client.
Oh, yes. Yeah. Mr. Riley. Oh, you're Mr. Riley. You're excused. You're excused. So for now, we're going to, just so you know, we're going to leave this on the calendar. And so when is the calendar call again for this, Ms. Robbins? The 28th. Yeah. Be prepared to come in on 28th. That could change, but talk about it with your attorney. Okay. All right. Thank you. All right. Position 3, Antonio Lewis.
I spoke to Mr. Lewis this morning, so I know he's on his way. I guess he hasn't made it here yet. But generally, my announcement for this case, we're missing discovery. There is a very key piece of discovery in this case that I emailed ABA Iqbal about, and I have not heard back from her. Also, we don't have an offer.
Well, Ms. Clark, I know you're here on behalf of Iqbal. Is there anything that you can speak to on that?
Yes, Your Honor. The discovery that 88 Iqbal is aware of the outstanding discovery. She has put a request in with the agency, so she's waiting to get that get that discovery.
Well, I mean, all right. I don't know what's the evidence you're looking for?
So I'm looking for, so basically what happened is Ms. Smith.
Yeah, can you come up to the microphone, Mr. Wilson?
So Essentially what happened is that the victim is claiming that she was shot by my client, and her initial response was that somebody else shot her. And so it isn't until the actual warrant that my client is ever named. So we don't have any body camera footage of the initial interview, and there claims to be time-stamped text messages between the victim and my client that would say that would show that he shot her, or at least that's what's alleged in the warrant. And those are pretty important things when it determines whether or not we're going to go to trial or not. So essentially, to sum up, we're looking for copies of the text messages and any body cam footage, because I would assume that the detective recorded the initial interview, but we don't have any of that. It's primarily the incident date and the body cam footage of the incident, or at least the aftermath of the incident, and the arrest of my client.
All right. It's hard to do this without Iqbal, but I know she's in trial. Let's leave it on the trial calendar for now. And Ms. Clark, can you pass on to her that she needs to get Mr. Hornsby Wilson and his client an offer?
Right. Well, Your Honor, if the evidence that that defense counsel has referenced that he needs, I do have notes from ADA Iqbal that she has put the request in from the agency. This evidence would be exculpatory. So definitely.
Well, I know, but I need to find out when she put the request in, when there was notice, why, what agency, why is it taking so long? You know, I need answers to those questions, because if it's just as simple as just saying, well, I put a request in, let's continue the case, I'm not going to have anything left on my calendar. So if you could just pass that on to Iqbal for now. Thank you. All right.
So we'll be back on August 28th.
Yeah.
And Mr. Lewis is here. He did walk in.
Okay. Well, I was going to tell Mr. Wilson he could text you and tell you didn't have to come in. You know, because we're just going to have to continue it. I don't know if you heard Mr. Lewis, but there's still some outstanding evidence, and your attorney has not received an offer from the state yet. So we're going to leave it on for now. That could change.
Okay.
But I do want to hear a little bit more on the background of all this, where the evidence is and what's going on. You know, before we just start punting things off the calendar. Okay.
May Mr. Lewis be excused?
You're excused, Mr. Lewis. Position 4, Deontay Atkins.
Judge Paul Kish on behalf of Mr. Atkins, who's here and standing. We finally got discovery. I've been trying to get the state to respond to me. I've received no responses.
What do you mean, on a potential offer?
Yes, sir.
Who has this case?
Iqbal.
All right. I mean,
Your Honor, I have Iqbal's announcements, if you'll let me respond on her behalf. ADA Iqbal's offer to the defendant is
well,
yes.
I mean, I guess it's fine to announce the offer, but we're not, I mean, you know what, don't, because I mean, that should be mentioned to the defense counsel first before we, you know, so you're going to have to, Ms. Clark, why don't you, when we take a break, why don't you get Mr. Kish's cell phone and at least announce it to the defense attorney before we start doing it in open court, okay? Did you hear me?
I hear you.
All right.
How should I get that to her, Judge, if he's not here? Can I just announce? I don't want to announce my cell phone number here, if I can avoid that.
Well, never mind.
You can have Ms. Robinson
I
put it in the chat.
I wouldn't either.
Sometimes I have to bite my tongue, but all right. Thank you. So let's, and can you just, I know Iqbal's in trial, but let's try to get these offers in before the final plea day. That would be helpful. So, you know, perhaps there's some communication, and these calendars can go more efficient. Right now, it's very inefficient. So let's
Did we stay around, Judge?
Yes, let's circle back and position 5, Gary Bernard Sermons. So I see you here, Mr. Sermons. Where Mr. Sterling, he's your attorney? Asking for a reset of today or asking for a reset for the whole trial? Let's see. It's a 2-week trial calendar, right? Our calendar. Yeah, I always want minimum 2 weeks. We may have to start going to, we're gonna do a massive calendar. I guess I'll reset it. Position 6, Leonard Hodges.
Your Honor, before you go on to position.
1 second. All right, go ahead. What?
Yes,
what-
position 5 is if the state would like to be heard on that case. Position 5 is my case. Discovery has been served, an offer has been made to defense counsel. We were in talks of trying to come to a resolution on that case. So at any rate, discovery has been served, and the state is ready to go to trial if the case needs to go to trial.
I'll tell you what, let's leave it on the calendar. I mean, he's got that whole week blocked out, but nobody knows more than me that it can, the 28th, whatever his trial is, it could be resolved by then. So let's leave it on the calendar. What, Miss Robin? Yeah, Well, Mr. Sermon's standing there. I'm sure you heard all that. So we're gonna. Oh, all right, Mr. Sermons. You heard all that, right? So we're gonna leave you on the trial calendar. We're just trying to work through a conflict with your attorney. I know he's been in contact with the state and they've discussed a potential offer. And so we will, for now, you are going to remain on the trial calendar, okay? Pardon me? The 28th is when you need to, you need to be back here. So, I'm sorry? 9:30. Yeah, you're excused. All right, position 6, Leonard Hodges. You were just standing a minute ago, Mr. Hodges.
Your Honor, I am present on that, Your Honor. The state and I have been in communication. We would just pre-try that this morning.
Okay. You agree with that, Ms. Clark?
Yes, Your Honor.
Okay. All right, position 7, Lumpkins.
Good morning, Judge Barry Zimmerman for Mr. Lumpkins. I've taken over the case. I know Ms. Jones had discussions with Ms. Iqbal. He's present, by the way, and I know an offer's been extended. I've been relayed, that offer's been relayed to me by Ms. Jones. I don't know for sure what that is. I asked calls with Ms. Iqbal yesterday, so I needed to pre-trial the case this morning. Maybe we could have come to a resolution, but obviously that's not possible. So.
Ms. Clark,
Yes, Your Honor.
can you reach out to, I guess it's Miss Beza, you think I know it by now, and just see if there's somebody from the DV office that can come in and pre-try these cases. There's so many Iqbal cases on here and it's just, it's becoming a waste of time.
Yes, Your Honor. Do you want me to do that right now?
Yeah, if you don't mind texting or just
Okay.
making a quick call, just see there's somebody down there. We've got a lot of attorneys, a lot of folks that have made the trip down here. And I just hate to, keep punting it, especially under the circumstances that we're supposed to be doing our best to keep people out of the courthouse and seem like we're coming up with ways to keep bringing people to the courthouse. So, if you wouldn't mind just reaching out, see if there's somebody down there that can, or over there that can help to pre-try these cases today.
Okay.
Thank you.
Yes, sir. Yes, Your Honor.
I appreciate that. All right.
Judge.
Yeah, you just stick around and we'll see. And Mr. Lumpkins is here, right? Yep. See you right there. Okay. Position 8, Jamal Thomas.
So, Your Honor, to be candid, Mr. Thomas has been on the final plea calendar for quite some time. He was here and then he left, and I've had no contact with him since. I've tried calling him.
You say when he was, you mean today he was here?
No, he was here probably about
It's been a
2-3
number of
months ago.
times. Yeah.
And he was here ready to take a plea, and I don't know if he thought it was done, if he thought it was over with, but he left, and I contacted him because we were supposed to be put on the final plea calendar for like that following Thursday. And he said he was going to be there, and then he wasn't there. And I haven't had any contact with him since that day. Now, I know he potentially had some things in Louisiana, so he might be somewhere else, but I have no knowledge of where he is. And the number that I was using to call him goes straight to voicemail when I call.
So Ms. Clark, did you hear all that?
Yes, Your Honor. Well, this case was set to plea as Mr. Hornsby Wilson has indicated. Last time I reserved not requesting a bench warrant for the defendant's absence because of the fact that we were trying to resolve the case. But Your Honor, the state is going to have to request a bench warrant in this case and bond forfeiture.
I mean, I'm looking at the charges. I can't imagine this is,
I don't really have an answer, Your Honor.
I know, and I don't expect it to. But I'm just sort of surprised that he's not here, given the
Yeah, I
charges
mean-
I'm looking at, but.
We had come to a resolution. I thought we had come to a resolution. So I know that I held off on two different settings.
Yeah, I remember, but it's, it's hard to do a plea when the defendant's not here. So, yeah, let's go ahead. I'll sign the bench warrant and do the bond forfeiture.
I understand, Your Honor.
Okay. Position 9, Bennett. Oh, position 9 and 10 is Bennett. Thank you.
Your Honor, I am present on that. Ms. Bennett is also here. Your Honor, on position 10, I just received discovery on that on Friday. I'm going to share that discovery with Ms. Bennett today and hopefully engage in some negotiations with the state, but I need to review that information, and it's a fairly serious case because it does involve a shooting. So we would just request a reset to the next trial calendar to give me an opportunity to review all the discovery.
Who has 9 and 10, Ms. Clark?
Position 10 is mine. Position 9 is 88 Iqbal, and I just was informed that she will be signing on, Your Honor.
Oh, okay, good. All right, so on position 10, so Ms. Jones says you just received discoveries. I don't suppose you've met any sort of offer yet, correct, Ms. Clark?
No, Your Honor, but I did talk with PD Jones on yesterday, and the state does not oppose the case being reset to the next trial calendar if the court is so inclined.
All right, we'll reset both of them to the next trial calendar. The thing is with, and I guess when she comes on, I can tell her with Miss Iqbal, I mean, I don't really need her to talk to me right now. I need her to talk to the other defense attorneys and see if there's potential for any sort of resolutions, and if there's not a game plan for going forward. But on position 11, Body.
Good morning, Judge. We're present via Zoom. That is 88 K. Charles's case, and my understanding is she's on an emergency leave. But we received I guess, a proposal this morning that would result in the dismissal of this indictment, but then a reaccusal to some lesser included charges. And I think that's the direction we're headed in to get this resolved. But given that she's out, we would ask to be reset, I guess, to the next final plea.
For the proposal, it's a proposal that they would re-indict the case with lesser charges if your client accepts. Is that what you're saying, Mr. Yates?
That's what I received this morning, Judge, about 6:30 a.m.
Okay. Well, I'm aware of Ms. Charles's emergency, so I will grant that reset to the next trial calendar.
Okay. And that's all Mr. Body and I have, Judge. May we be excused?
Your
You're
Honor, is
excused.
that
I'm sorry. Go ahead, Ms. Clark.
Yes, I'm actually making the announcements for.
No, and I apologize. I keep rolling through your side of it, but go ahead.
88 Charles, and as counsel has indicated, that is what 88 Charles intended. And are you going? I just wanted to clarify. Are you resetting it to the next to another final plea calendar or to another trial calendar?
Well, so Mr. Yates, you've still got to discuss all this with your client and work through it all. I mean, is there another plea calendar before the? I mean, yeah. Let's reset it to whatever the next plea calendar is. September. All right, so next plea calendar will be in September, but we'll reset it to that day.
Thank you, Your Honor.
Thank you, Your Honor.
All right. All right, position 12. Nidi, how do you pronounce the name again?
Boubacar and DA.
Okay. Nadia, all right, Mr. Clark, go ahead.
Yes, Your Honor. And this is Ms. Iqbal's case. We had reset this from the last final plea. The state has given an offer, which is the minimum to these charges, but it indicated to me that there was a high likelihood we're going to be able to work around that. And we reset it to give us further time to discuss. I've not been able to discuss with Ms. Iqbal the further offer. Given the seriousness of the charges, I don't think it's something that we're going to be able to pre-try and resolve today based on that. So I would ask that it be reset to the next final plea calendar to give us more time to discuss this and see if we can come to a resolution, which, as was conveyed to me, it seems like the state is going to be able to find a way to offer a resolution to this case that might be favorable to both parties.
I'll tell you what, just since Iqbal's coming on, let's circle back to this one.
Yes, Your Honor.
All right. Okay, sure, 1 minute. Oh, okay. I gotta step out for a minute. Position 25, Muhammad. No, I know, but we're just skipping.
Oh.
We're skipping.
Good.
Sorry, it's out of turn, but
Your Honor, I am present on that case. Her co-defendant is position 24. She's present. I would like to pre-try that this morning. The state and I have been in conversation in regard to a resolution.
yeah, for some reason, gosh, it didn't print out. So let me pull that up my computer here. Position 24, Rogers.
Stepped out, so she is here. I believe that'll be a resolution this morning, Your Honor. I just need to talk to ADA Clark about one little thing. And I've already emailed her.
Okay. Can you do me a favor? For some reason, it didn't print out, reprint out the calendar for me because I'm going to run out of spots here. All right. Pardon me? Do the whole new calendar. Yeah. Yeah. Okay. Position 13, Porter.
I am present on that, Your Honor. I haven't had a chance to speak with Ms. Iqbal in regard to this case, but if she's coming online, I'll definitely do that. So we can pre-try this.
Okay. Position 14, Tucker.
Same announcement.
You're here. Good. It's the strangest thing that it doesn't print the middle pages anymore for me. But that's my problem. It's not operator error. It's an IT issue. Have you got it? What did I just do? I did 14. All right, position 15, usher. Rockwell has it.
Good morning, Judge. I'm sorry, Judge, could I announce on this matter, we've gotten some new discovery here of late. Could I ask for another final plea calendar? I don't think the prosecutor would object to that. There was
Uh-huh.
initial discovery, but we had some extra discovery that we were just able to get. So instead of asking for another trial calendar, I'd love another final plea.
Your Honor,
What
position 15
prosecutor
is-
has it?
Yeah, Your Honor, position 15 is my case, ADA Clark, and the state is not opposed to the resetting of the case to another final plea calendar at Ms.
What-
Rockwell's request.
I mean, have you received an offer yet, Ms. Rockwell?
Judge, we're in communication. We just, we had expected and have now received some additional discovery. So, if it's, if
What
it's
sort
not
of
asking for too much,
what sort of
Um,
discovery is it?
well, it's some extra, extra videos, Judge, and some, paper discovery. And I would like to go over it with the client. So I've heard other lawyers asking for further notice to a different trial calendar, but I'm going to ask for further notice to a different final plea.
Well, I've given about half of them that continuance, and half of them are still on this trial calendar. But
Well, could you put me to the very bottom then? If you, I mean, not that we're going to get reached or anything. I just, I don't quite remember how you do your final pleas, if it's non-negotiated after the final plea, et cetera. Could we just stay on the trial calendar? But if we come up to the top and decide to resolve it, could you treat it as a final plea? How about that?
yeah. I mean, we're going to have a calendar call on the 28th, and that just a lot of times ends up being the final plea day.
There you go. Okay, I won't say anything. Thank you, Judge. I'll stand down.
Okay, all right.
I do
all
have
right.
one more person, so I'll stand down.
Okay, thank you. All right. Position 16. Well, that's right. You already spoke for them, Ms. Clark. So I'm 15. Position 16, Tolbert.
Good morning, Your Honor. Ben Gutierrez here on behalf of Mr. Tolbert. I hate to make this request after that last discussion, Judge. I am requesting continuance to the next trial calendar, Judge. The state was doing, last time we were here, they wanted to do some further investigations prior to making an offer. I would like an opportunity to have some more in-depth discussions with the state as well. And I can say I believe this will be my last request for continuance, Judge.
Who's got this with the state?
Your Honor, ADA Clark, this is my case.
All right, Ms. Clark.
The state doesn't oppose that, Your Honor. I think that if we can come to a resolution certain, save the taxpayers money without going to trial on the case. So why not?
I understand, and I'm open to all negotiations.
Well, I mean, if we just leave it open-ended, it can just go to infinity.
Your
So
Honor, if you could reset it for 60 days, please.
oh yeah, we'll have a trial count in October. When people be coming here wanting continuances because they want to take their kids out to Halloween, but we're going to have an October trial calendar. All right, I'll give you the 60-day continuance. But that's it. No more, no more on that, all right?
Your Honor, and also too, could you, so I know it'll be on the trial calendar in 60 days, but could you also ask Ms. Robinson to put it on the final plea calendar for that same?
I think she does that
Time frame.
automatically, don't you, Miss Robinson? Yeah, she does that automatically.
Okay, all right. Well, thank you so much. All right.
All right. Our 60-day continuance resolution. No more continuances. All right. Position 17. Simpson. See, Mr. Simpson, Mr. Clark, where's, Mr. Clark, is he out talking to a client or?
So, Your Honor, I think he stepped out for a moment.
All right, we're gonna circle back to you, Mr. Simpson.
Okay.
Position 18, Davis.
Good morning, Your Honor. Ms. Davis is present this morning. Judge, I came to arraignment back in December. There were some discussions about potential diversion on this case. I haven't heard anything else on that end. Since we received the one-page incident report as discovery and audio file as discovery back in June. So we're here. That's all the evidence the state has. Yes, we've received all the evidence. I don't know that I've seen any updated offers or any other discussions, but.
And you're Mr. Watson?
Yes, sir.
Who has this with the state?
Judge Shama Iqbal for the state.
And so, and I don't recall if that would have been Ms. Iqbal I discussed everything with back in December, or if that was someone else, but I'm happy to retry it.
I have an offer, Your Honor, and discovery has been served. I can definitely pre-try it with him.
Okay, all right, we'll circle back around to this one.
Thanks, Judge.
Thank you. Position 19, Bigby.
Bigby's present, Your Honor. That was going to be a resolution this morning. I'm not sure if we're still going to be able to do it. This is Ms. Charles's case. So I don't know what position we're in, if Ms. Clark would be able to handle it, or if that would just need to wait for the calendar call on the 28th. But I did speak with Ms. Charles, and this is going to be a resolution.
Ms. Clark?
Give me one moment to review what Ms. Charles has for that case, please.
Position 20 is the co-defendant. Okay, thank you for pointing that out. Yeah, this is an old one. Yeah, it's been re-indicted, granted a state's request. Of course, there's been extenuating circumstance since then, but
Your Honor, I should be able to take the plea as I have the terms provided by ADA Charles, but I need to, I will need opportunity to review.
sure.
To review it.
We'll take a break at some point and you can do it then. How about getting to the co-defendant, DeMar?
Mr. DeMar is on the Zoom. I spoke with ADA Charles on Friday and I proposed a counter proposal. I am just waiting to hear back whether or not that was accepted. And I don't know if ADA Clark would have any insight into that.
Well, maybe Ms. Clark can look into that on break. Is that all right, Ms. Clark?
Yes, Your Honor.
Okay, all right. All right, position 21, Simpson. Okay.
Yes, Simpson present. Good morning.
That's different Simpson.
Oh, okay.
No, I see what Ms. Meyer saying. This is Alex Simpson.
Yes, Alex.
Okay.
Good morning.
Yeah, Alex is on Zoom. I see him.
I am present on that, Your Honor. ADA Matt Holmes is the person prosecuting this case, Your Honor. We continued last time to get medical records. I am in receipt of those. I've reached out to Mr. Holmes in terms of how I can provide those to him. I haven't heard back, but I feel fairly confident that if this just rolls to the 28th, we'll be able to resolve it.
Okay. Ms. Clark, do you have anything to add to that? I know it's not your case, but I don't see Mr. Holmes.
Your Honor, yes, that you can go to the 28th, please.
All right, we'll leave it on the calendar. Mr. Alex Simpson, you're excused.
Okay, thank you. You all have a good. Bye.
Oh, thanks. 17 with Robert Simpson. You were out in the hall, Mr. Clark, when we called it.
Mr. Simpson is present. We received discovery on this case. I think we're missing a witness statement from the alleged victim. I don't imagine that would be a holdup in this. Mr. Simp, we have not been conveyed an offer. My understanding was this was supposed to go to the adult quack prosecutor. I haven't received any communication yet. I'd say Mr. Simpson's just standing on his not guilty plea at this point. We filed a plea in bar as to count 2 back on December 12th of 2022. So before this would go to trial, you know, we would ask to be heard on that. Otherwise, he's standing on not guilty at this point.
Anybody from the state?
For, you said, what position is this, Your Honor?
Position 17. We've jumped around. Mr.
Okay.
Clark was outside talking to a client when we first touched on it.
Well, that would be, Your Honor, that would be somebody from sexual assault unit. So I will need to get someone to sign on for that.
Okay. Let's circle back to this. I mean, it sounds like I'm going to reset it just because we're going to have to hear that plea in bar, but I would like to know who the prosecutor is on it. So,
Okay.
thank you.
Well, starting, Your Honor, starting on the 21st of August, it will be 88 Precious Marsh. And I will send.
Oh, yeah,
that,
I've met her.
Yeah, I will send that contact information to PD Clark.
What's her last name again?
Marsh, M-A-R-S-H.
That's right. Yeah, I've met her. All right, so Precious Marsh is the ADA. All right, so it's not necessary to circle back then. I'll reset it, but we're going to need to schedule that motion that, pardon me? No, I'm going to have to, we're going to have to hear Mr. Clark's motion. So I don't think, do you think we can do all that and do the 28th and
On the
and
28th,
Ms. Marsh coming online? I don't think so. I think we've got to reset it. So let's reset it and let's get it on a trial calendar and get the motion scheduled. Okay. All right. Thanks.
Your Honor, and I didn't hear PD Clark. The motion that has been filed is what? I'm sorry.
it's a plea in bar. That's the count 2.
Okay. All right. Okay. Thank you.
All right. Position 22, Joy Fields.
Ms. Fields is present, Your Honor. I need to pre-try that case with the state.
Okay. And is that one yours, Ms. Clark?
Yes, Your Honor, it is.
Okay. Position 23, Perry.
So Ben Githier announcing for him. It's my understanding on behalf of Mr. Adams, they have received discovery. An offer has been made at this time. Judge, they're asking you to place on the trial. Of course.
Your Honor, could you have the attorney make?
Say he's on it.
Okay.
Yeah. Why don't you? That's right, because the attorneys, the prosecutor's on Zoom.
Excuse me, just elaborate. Yesterday, I filed a motion for.
Wait a minute. Who are you, Mr. Perry? Let's. The only concern I have, you're represented by counsel.
And I filed my own motion for a motion to dismiss, so I can have a cause hearing, so we can cross-examine the witnesses.
All right. Why don't you hold off on that? We're not going to hear your motion, but we need to, Mr. Gethia, is it again?
Githier.
Githier.
Yes, Judge.
Sorry.
Let me read verbatim from the. I'm sorry, for the state, discovery's been received, an offer has been made. They're rejecting the offer at this time and it has to be placed on the trial calendar. I understand that this is a trial calendar, Your Honor.
Okay.
I understand, Judge.
Just want to make that clear.
Of course, pending any conflicts Mr. Adams has, because I will not be trying this case, just.
Yeah, so Adams has filed a conflict because he's tied up with, so he's filed a conflict for this trial week. I'm trying to pull it up right now.
It's possibly ongoing, Judge. You know, that trial.
Possibly.
It just doesn't end.
They're gonna have it all wrapped up in 2 weeks.
I'd stand corrected. It's definitely a conflict, Your Honor.
Yeah. Well, no, I know what you're saying, that there may or may not be something going on that week, but okay, all right. So you received discovery, you've received an offer, you've rejected that offer.
Correct, Your Honor.
And Mr. And I'm going to be real careful asking you this stuff, but Mr. Perry, so when did you file your motion to dismiss?
I found it yesterday.
Okay, so I don't see it on here right now.
Yeah, it should be on right now.
All right, well, more than likely that's going to be a nullity because you're represented by counsel. So you're going to need to call your attorney and talk through that, okay?
Right. Somebody, can we put on the calendar for a motion here?
I mean, I'm just giving you some insight right now that there's about a 99% chance that I will dismiss it for being a nullity because you're represented by an attorney right now. So you need to talk through your motion with Mr. Adams and discuss, whether you guys are on the same page. And so that's a private conversation you need to have with him. You don't need to do that in open court while that's being taken down. Okay. You understand all that?
We have another final plea hearing. I never said.
Yeah. I'm in the process of resetting this. So I'm going to reset this. You will have another, I will tell you right now, you will have another final plea as Mr. Githia has just said on behalf of Mr. Adams. You've received an offer. You've rejected the offer. I expect your talks will be ongoing with the prosecutor. Maybe they won't be. I don't know, but you'll have a final plea, but you need to discuss your motion that you file with Mr. Adams. Okay. All right. Okay. For now, you're excused.
Your Honor,
All right.
Before the defendant goes.
Oh, wait a minute. I keep
yeah.
forgetting about the prosecutor. Sorry. Go ahead, Ms.
Okay.
Clark.
If there is a motion to dismiss that the defendant has filed, and if he feels that motion is warranted, make sure that he conveys that information to his attorney so that information can be provided to the state. So we can.
Well,
review
yeah,
that.
I just told him that he needs to have a conversation with his attorney about that motion, but I don't want to get into any of the details of whether, about why he filed or what he wants, but he needs to have that discussion with his attorney. Okay. Because it's your attorney that needs to be filing things on your behalf. Okay.
I understand. And there's a reason,
Well, and I want to cut you off when you start talking about the reasons for things because I don't feel comfortable with that in open court. All right, but beyond that, you're excused, okay, Mr. Perry? All right, thank you. You're welcome. Position. So we already touched on 24, right? Yeah, those are pre-try. All right. Position 26, Mr. Davis. That's Renee Rockwell. Miss Rockwell, are you on? I see your client's on as well. You're both on Zoom.
Sorry, Judge. Whenever I put y'all, it takes me a while to jump back in. Judge, I maybe have been texting Miss Christina Clark. I think I need to speak with Miss Iqbal on this. Could I just stand down and see if there's a way? I've got a counter offer. If we can perhaps move this today, I'll be happy to stick with y'all this morning We're
Okay.
all done. Thank you, Judge.
Position 27, Butler.
Good morning, Judge Maya Griggs here on behalf of Mr. Butler, who's present in court. I am actually ready for trial. I think I.
What?
That on the last final plea calendar. It's my understanding that the state still is having witness issues, and I have been in communication with 88 Trials in reference to this. And so not only would we like to be moved to trial calendar, but you can call us first if you'd like.
Let's look through this here. So. All right, Ms. Clark, have you heard all this?
I did not, Your Honor.
Oh, that's right. You're not at a microphone. If you want to sit there, you can come to the podium. Come to the podium.
Good morning. I was trying to see your face on here. I don't see you, but my announcement is that we are ready to be moved to the trial calendar and requesting to be placed first or called out first. I've been in communication with 88 Charles. I'm aware of her emergency. However, she indicated that she had the opportunity to speak with supervisor and is waiting for response on a possible resolution. However, based on the witness issues, we would like to go forward as to not create any further delay.
Okay. When Ms. Clark, I know you're, do we know when Ms. Charles is going to be back?
The 23rd.
Oh, okay. All right, Ms. Clark, I know you're taking down notes for Ms. Charles, so we'll leave this on the trial calendar and just come back for the calendar call on the 28th.
Yes, Judge. And I would just, for the purposes of the record and for the court's awareness, she indicated the date, so she knew that it was on the 28th and is anticipating potentially this being a resolution on that date.
Okay.
All right, thank you. And then that concludes my business. May myself and my client be excused.
You're both excused.
Thank you so much.
All right, thank you. Position 28, King. 28, 29, and 30, Mr. King, thank you.
I am present on that, Your Honor. We would like to pre-trial that. I've talked with the state and I think we're just firming up a potential resolution, Your Honor.
Okay, who has it with the state? Is it you, Ms. Clark?
Yes, that's my case, Your Honor.
Okay, you can pre-trial that one. Position 31, Chance.
Mr. Chance is present, Your Honor. We've been conveyed an offer by the state. Mr. Chance is standing on his not guilty. We'd ask to come back on the 28th.
Who do you have this one, Ms. Clark?
Yes, that's my case, Your Honor.
Did you hear that?
I did.
Okay.
I understand he's rejecting the offer.
What was the offer?
10 do, I'm sorry, go ahead. I'm sorry, PD Clark, go ahead.
The state, it's the state's offer, so I'd let you convey it.
The offer was 10 years, 3 years in confinement, balance probated.
What's the max on an aggravated assault charge?
20 years.
So minimum, he could do over 660, right? That's not even
Right.
including the terroristic threats, the possession of a firearm. All right. So Mr. Chance, I'm sure your attorneys explained this to you. You know, if you go to trial and if you're convicted by a jury, you could be sentenced to more than 60 years. You understand that? Okay. All right. We will leave this on the trial calendar then.
Yes, Your Honor.
Is everybody ready? Are you ready to go to trial on this, Ms. Clark?
Yes, Your Honor, the state is ready.
Okay. All right. Thanks. You're excused, Mr. Chance. Position 32, George Hardy. See Mr. Hardy?
Good morning, Your Honor. Alex Mitchell. I'm sorry, you were skipping around.
That's all right.
I guess walk up to speed.
That would be helpful because the prosecutors are all by Zoom right now. You may have heard there's some other stuff going on.
There's a lot of stuff going on.
Yeah, I like to think there's some stuff going on right here, but
I would be requesting a continuance to the October calendar as I just received additional discovery Friday. I haven't received the offer yet from the state. However, since I stepped in on the middle of the case, I'm not sure if an offer was conveyed originally and she just forgot to send me the same offer. But I do expect to be filing some motions here soon based on the new discovery that was sent. And so that's why I would be requesting to have it moved to the October calendar date. I think in the meantime, we can probably work on getting a resolution by then.
who has this with the state?
Good morning, Your Honor. Shama Iqbal for the state. An offer has been given. It was given to prior counsel, Your Honor, of 5 years of probation. Family Violence Intervention Program, no contact with victim.
Yeah, I still want to do a 60-day continuance because I'm going to be expecting to file some motions regarding the evidence that was provided Friday. And the evidence was provided was pretty much the full discovery packet with the offer missing. At first, I only had the police report. So there's hours of video that I need to review with my client. I've had a chance to review it. And so I just want to be able to go over it with him and let him know that what we're planning to do as far as motions.
And
All
Judge,
right.
we filed discovery in this case in January 11th, 2023. I don't know what this new discovery he mentions. I didn't send anything recently at all. So I can talk with counsel to figure that out.
Yeah, I have the email where I just received it Friday. So again, like I said, I came in on the middle of the case. So she probably did provide prior discovery to the prior counsel. However, I didn't get the.
Well, and I hear you, and frankly, I'm probably more understanding with the defense lawyers and some that come in the middle of the case, but there is some obligation when you take the case on, when the trial is. I'll tell you what, stick around. Iqbal is going to be available. Why don't you talk to her and then we'll readdress this a little bit later, okay?
Okay, thank you.
All right. Yeah. I don't know what to tell you. He's not here now, and I'm going to take a break and just let everybody. I'm sure there's got to be some coordination with Zoom, some phone numbers passed. So just do me a favor and call me when I need to come back out. Is there anything else we need to address before I take a break? Okay.
Hello?
I'll talk to you in a minute. Yep. Yep.
Hey, Miss Iqbal, if you're there, what was your name? Mr. Zimmer?
Yeah.
Mr. Zimmerman would like me to send you his cell number, and I'm gonna go ahead and do that in the chat so that you can reach out to him.
Yeah, I think she has.
Yeah, I just want, I dealt with Miss Bennett. I just let Miss Bennett go get her, gave her her stuff. All right, Mr. Hodges. she left me. It's at one, right? You know that one? I know, but I.
Sir, keep going.
Okay, I'll let the court know, but you'll come back the 28th. Yeah, 28th. Okay, I'll let the court know. Oh, is that for Mr. King and then.
Is Ms. Iqbal present? Ms. Clark?
Thank you.
They got forms for doing please?
They do, and Ms. Robinson, when she's here.
Okay.
Yeah. How long was?
I was the chief. Federal public defender.
Oh, all right, wow.
Yeah. Most of my stuff's over there.
Yeah. Gotcha. Yeah.
Hey, Ms. Clark, how are you? No, you're fine. No worries. Hey, so Mr. Hodges is actually gonna change parts. He's gonna take the 4-year probation. But he had to, he's had to go to the funeral, so he left and, we'll just have to. Is that okay? So that's what he told me today.
Hey, Sean.
Oh, yeah, so that, so don't worry about that. Not that I'm aware of. Okay, I'll talk to him. Okay, okay, bye-bye. No, this is how I am. I just make big messes. Yeah, I'm waiting for her to update me on. I just got done talking to her. Mr. Porter? Come on.
Ms. Clark? Yeah.
Roger, I think your mic is on. Go ahead and cut that off. Yeah, Roger, I just want you to cut your mic off.
Mr. Hornsby Wilson, can you hear me? This is 88 Clark.
Yes, I can.
Were you talking to me or someone else about you couldn't?
I was talking to my client.
Oh, okay. My apologies.
You said cut it off?
Yeah. Okay.
Roger, I just want you to cut your mic off.
Huh?
Roger, I just want you to cut your mic off. You just
I
cut
can't hear
your
you.
mic.
I'm sorry. Hold on. What'd you say?
Just cut your mic off. That's all I wanted.
Cut it off? Oh, okay. I thought I cut it off. Okay. Let me see.
I think they're working on it.
Okay. Paperwork or whatever, do you need paperwork? Okay.
Some announcements.
For now.
Yeah. I have one plea and I'm waiting on, I just printed some because I couldn't. You were in the back.
Yes. With the hour.
Ms. Clark. Oh,
sorry. Oh, okay, got it. So. If you want to sign copy. It is, yeah, we. Just hold on to that. Okay, sounds good.
Oh. My client's having a meltdown out there. What is going on here?
Okay, so the one I gave you is good. Okay, cool. That was like.
See more color. I was, but then I realized I could just print this from here. I forget we have a printer.
Yes.
Everyone, y'all understood what I said. Only people allowed to use the phone in here is the judicial staff. You're not a judicial staff, can't use the phone. Come to order, remain seated.
Okay.
First.
Okay. Okay, well, these make sense to address now anyway, and then I may, which positions are those? Okay, well, let's go ahead, since this seems pretty straightforward, let's do position 18. Well, first of all, is Miss Iqbal on?
Yes, Judge, I'm here.
So let's do position 18, 22 SC 184595, Dakara Davis, who is represented by her attorney, Mr. Watson. They're both present in the courtroom. We have Miss Iqbal with the district attorney's office appearing by Zoom. Go ahead, Mr. Watson.
Yes, Your Honor. We have presented I guess, a consent agreement for my client, Ms. Davis, to enter the pretrial intervention program. We're asking for the case. This agreement would lay out the case would be dead docketed until she completes the family violence intervention program, and that she have no contact with Bruce. How do you pronounce his last name? Ergang?
Ergang. Mr.
Ergang during that time period. My client's in agreement with this. That's what we're asking the court to accept here today, Judge.
Okay, Ms. Iqbal, I see that your name's on here with Mr. Watson, and you're in agreement with all this?
Yes, Judge, I drafted the order.
Okay. Okay, looks very straightforward. I'll accept it and sign the order.
Yes, Your Honor. I'll keep the court apprised of my client's progress and Ms. Iqbal as well.
Anything else?
Yes, sir.
Okay. There's that one. And let's go to Hardy next. And what position was that? 32? Okay, I see Mr. Hardy. All right. So this is 22 SC 184474, George Hardy, who's joined in the courtroom with his attorney, Mr. Alex Mitchell. And we have Ms. Shama Iqbal with the district attorney's office appearing by Zoom. So I also have this order in front of me. Mr. Mitchell, go ahead.
Yes, we are accepting the terms of the PTI, which is the FVIP course, drug and alcohol evaluation, and plus no violent contact with the victim.
Okay, Ms. Iqbal, anything else you want to add?
No, Judge, that's pretty much it. And the reason it's no violent is they're married. Is that correct, counsel?
Correct. They're still married.
Okay. I figured there was some sort of relationship there. All right, I will accept this and agree to it. I'm signing it as we speak. Anything else?
No, Your Honor, other than to get a copy, that's it. But that concludes my business for the day. My client and me be excused.
You're both excused.
All right, thank you. All right, you go ahead.
Are there any other announcements that we have that aren't going to be pleas, just so we can clear those?
Yes, sir.
Go ahead. I'll tell you what, Mr. Hornsby Wilson, you go ahead.
Roger DeMar. whose position-
Why don't you come up to the podium since not everybody's present in the courtroom?
So Roger DeMar, which I don't know the position off the top of my head. 20.
Okay.
So I spoke with ADA Clark, who's standing in for ADA Charles, and it seems, well, our understanding is that the case will be accused with lesser charges. And so we're just asking to be put on that, kept on that 28th date, so that hopefully that'll give us enough time to re-accuse the case with lesser charges.
All right, Ms. Clark, are you in agreement with that?
Yes, Your Honor, I am.
All right,
That, those are the instructions.
we'll keep it on the 28th.
Thank you, Your Honor.
Is that it for your announcements?
Yes.
All right.
Please, Form Judge.
Oh, okay. Ms. Jones, I see you're standing. What's,
Yes, Your Honor. Position 6, Leonard Hodges, Your Honor. He changed his mind today and is going to take that plea. However, his sister died and he actually informed me of that last week. The funeral was today. I told him we'd try to get him out of here. I thought he said 1, but it was 11. So I just like to take that plea on the 28th.
okay, Ms. Clark?
Your Honor, the state is fine with taking that plea on the 28th.
All right, we'll do the plea on the 28th then. Position 6, Leonard Hodges. Anything else, Ms. Jones?
Yes, Your Honor. Position 13, Daryl Porter.
Okay,
The state and I continue to talk. However, at this point in time, the state wants prison time. So I'm just going to move that to the 28th and continue to talk with Ms. Iqbal. And if we can work something out, we can.
okay, you hear that, Ms. Iqbal?
Yes, Judge, sounds good.
All right, we'll move it to the 28th.
And this other position, position 14, Your Honor, Edward Tucker.
Yep,
That offer also involves some prison time, Your Honor. I would just move that to the 28th and continue my discussions with Ms. Iqbal.
okay.
And Judge, just to put on the record that offer expires today, the new offer that I gave Miss Jones.
He's aware.
Okay, what is the offer?
Today it's,
Go ahead, Ms. Iqbal.
no, you can, okay, 20 to serve 10, Your Honor, is that offer for over all the charges.
Okay. So the offer expires today.
And it'll go back to the revert to the 40 serve 20.
Okay. You hear that, Mr. Tucker?
Mr. Tucker, did you hear that?
And
You've got
Judge,
an offer of 20, according to district attorney, you've got an offer of 20 to serve 10. It expires today and their offer goes back to 40 to serve 20. You hear that, correct? Well, I don't want you to get into your thoughts on the case because that could incriminate you and you need to talk to your attorney about that. I'm just wanting to make sure that you understand what the offer is now and what it reverts to after today. You understand all that, sir? Oh, yes, okay. All right, so are we done with Mr. Tucker today, or does he want to stick around and think about it, or what does he want to do?
I think even if you want to talk with me, I will.
Okay, he can stick around then.
If he doesn't want to take that plea, Your Honor, may I just excuse him though, so we don't have to go through that?
Absolutely, yeah. If you come in and say Mr. Tucker's gone, that is fine.
Okay, thank you.
Okay,
And I had some.
Yes,
I had some announcements as well, Your Honor.
okay, go ahead, Mr. Clark.
Position 12, Mr. Bubakar and NDI. I had previously made an announcement. I'd spoke with Ms. Iqbal about this. This is a case obviously where there are mandatory minimums involved. In speaking with Ms. Iqbal, it sounds like I can let Ms. Iqbal speak to this, but it sounds like we're still in the process of trying to see if we can work around that and come to some sort of resolution. It doesn't sound like the state's going to be ready on their end before the 28th. So in light of that, I'd ask if we could move it to the next final plea, and I'd let Ms. Iqbal speak on that.
And Judge, that's correct. Because this is a mandatory minimum and I'm wanting to deviate underneath that, I'm having to go up the channels to get approval, and I'm in the process of doing that. I've already started, so I just ask for another date, Your Honor, so I can get a offer that's lower than the mandatory minimum to Mr.
All right, well,
Clark.
so we'll leave it on the 20 for the 28th, then we'll leave it.
My supervisor's out this week, so I would prefer if there was another date that's maybe a couple weeks out past that, if possible, Your Honor.
I'd like to, and I would just say, I don't know where we're going to fall down on this offer. Just given the nature of it, I think it may be more appropriate to have it on the next final plea and hopefully let's come to resolution then.
I will put it on the next final plea and trial calendar.
Yes, Your Honor.
Okay. So we'll reset this one.
And then, Your Honor, position 22, Ms. Joy Fields, she's present. I had a chance to pre-try this with the state and offer them some more information. I had spoken, I'd gotten discovery on this case last week. It appears that I was sent some incorrect body camera footage, though. I know this case has been continued several times, but I would like to have a chance to review that because I think I think we're in a position where we're close to a resolution. I think Ms. Clark, in speaking with her, needs more time on her end, potentially to be able to talk with the alleged victim and see if there's any movement on the state's offer, if they're going to be able to do that. I'd also like to have a chance that there is body cam footage out there that could be pertinent to this. And if it does in fact exist, to be able to view that as well. I could not see this as provided that I get that body cam footage going, past one more final plea calendar. I just don't imagine that would be possible. And I do think we are going towards a resolution in this matter. So I understand this has been continued several times. I just ask the court's grace if we could get one more reset.
All right, we'll reset it one more time. One more reset. This is Joy Fields, position 22. We'll put that on the next calendar as well.
Thank you, Your Honor. And position 19, Your Honor, Priscilla Bigby, that will be a plea this morning. She has to pick up her children and leave here by 2. So I just wanted to make the court aware if we could get that done whenever.
Okay. Have you got the paperwork in?
I have, Your Honor.
Okay. Is that it with the announcements?
Yes, Your Honor.
All right, so we're ready to go. You want to go ahead and just do Big B? Is that paperwork in?
Your Honor, we need to, that is the case that I'm going to be standing in for 88 Charles on. And so I will need to, because I've been using this time to pre-try with defense attorneys, I'm going to need an opportunity to review that case file before I can do that plea.
Okay. Well, I'll tell you what, are there any that we have teed up that Iqbal is?
Yeah. Well, we don't have it teed up, but we have an agreement on Lumpkins.
We need the paperwork though.
I don't have, oh, now I do.
All right, now you do. Well, I'll let you. So what?
We have
What-
Ms. Muhammad and Ms. Rogers.
Those are both Iqbals?
I don't think-
Well, Clark.
Well, they're both Clark. That won't do any good because she's got to. Well, I guess she can do those now and then go to Charles. Yeah, let's do those. Go to the Big B case. All right, hand me the. So, Ms. Clark, are you ready with Muhammad and Rogers? You're on mute.
My apologies, Your Honor. I know that I was aware that Ms. Rogers was taking one, but is Ms. Muhammad taking one also?
Yeah, I mean, I've got the paperwork.
Okay.
Well, which one do you want to do? Are you ready with Rogers?
Well, PD Jones is not here, so I would assume Rogers will go first.
Okay. Who's got Rogers? I don't have my. No,
I
I know
have
you have.
Rogers.
That's the one thing I know. I don't know who else has. I'm talking about which. Oh, that's right. You are the public defender. All right. We'll put that to the side. So what position is Rogers?
I'm gonna go with 24.
Rogers is 24, Your Honor, but can you give me a second to switch gears here?
Sure.
All right.
September is going to be a big calendar. We're going to have a big one. All right. Oh, that's right. Okay, so they're co-defendants.
Okay, Your Honor, the state is ready to take Ms. Rogers.
Okay. All right, so this is 22 SC 1819224. Alyssa Rogers, who's present in the courtroom with her attorney, Mr. Brandon Hornsby Wilson. And we have Miss Christina Clark, who's appearing by Zoom, who's with the district attorney's office. It's my understanding you have a negotiated plea to present.
Yes, Your Honor, the state does.
Okay, go ahead, Miss Clark.
Thank you, Your Honor. Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You can put your hand down. Please state and spell your true, correct, and legal name.
Alyssa Rogers, ALYSSA RODGERS.
Defendant Rogers, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Yes. Medicine.
Okay, and what is the medicine that you're taking?
It's for depression and anxiety.
Okay, and does this medication affect your ability to understand this proceeding that we're doing right now?
No.
Okay. Is this medication prescribed?
Yes.
And the dosage that you take?
Just one pill each.
Okay. Does not taking this medicine impact your ability to understand this proceeding?
No.
How old are you?
24.
What's the highest level of education or the last grade you completed?
High school, I graduated.
And where did you attend high school?
I just got my GED.
Okay. Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the following offenses? Give me one moment. Count 1, willful obstruction of law enforcement officers by use of threats or violence. Felony, the state will be no crossing that charge. For count 2, simple battery against police officer. And count 3, obstruction of law enforcement officer.
Yes.
ADA
Do you
Clark, just,
understand?
well, I hate to stop you, but just for clarification, will that simple battery be reduced to disorderly conduct? And then with the obstruction, is that going to also be no cost? I want to clarify.
Okay, yes, so the simple battery against a police officer will be reduced to disorderly conduct. That is correct. And then the count 3, obstruction of law enforcement officer, will be null pros. That is correct.
And count 1 is no prost?
Yes.
Okay, thank you.
Thank you, Mr. Hornsby Wilson. Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes.
And did you understand the waiver of rights form as explained to you by your attorney?
Yes, ma'am.
And is it your decision to waive your rights today?
Yes.
And did you sign the waiver of rights form?
Yes, ma'am.
Also, did your attorney review the indictment in this case with you?
Yes.
And did you understand the indictment as explained to you by your attorney?
Yes.
And did you sign the indictment as with a guilty plea today with your attorney?
Yes.
Your Honor, at this time, the state moves to tender the waiver of rights form and the indictment into the record.
Your signature is not on the indictment, Ms. Clark.
Thank you for bringing that to my attention, Your Honor. The state gives you express permission to sign my name.
Okay. All right. Well, I will, so moved as far as admitting it to the record.
Thank you, Your Honor. Defendant Rogers, have you had enough time to speak with your attorney about all of the charges within the indictment against you, including the facts and circumstances relating to these charges?
Yes.
Would you like more time to discuss the case with your attorney, Mr. Hornsby Wilson?
No.
Are you satisfied with your attorney's services?
Yes.
Attorney Hornsby Wilson, do you waive a formal reading of the indictment for purposes of this plea?
So waived.
Do you waive any and all defects in the indictment for purposes of this plea?
So waived.
Your Honor, the state is unaware of any outstanding warrants related to the charges within this indictment. Defendant Rogers, do you remember being arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
The state will provide those to you. The only charge that you will be pleading guilty today is the disorderly conduct charge, and the minimum is 1 day in jail. The maximum is 12 months in jail. However, the prosecution does have the right to recommend probation. But I'm just letting you know what the statute says as far as the minimum and maximum.
Okay, I understand.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For count 1, willful obstruction of law enforcement officer, felony, the state will null pros or dismiss that charge. For count 2, simple battery against a police officer, the state will amend that charge to disorderly conduct. The state will recommend 12 months probation. Defendant is allowed to do phone reporting. The state will not oppose the waiver of probation fees for the defendant. Defendant must be evaluated for mental health within 60 days of guilty plea. Complete treatment if needed, with a behavioral incentive date after 6 months if defendant gets into no trouble or does not have a probation violation. She can have her probation terminated at the end of 6 months. For count 3, obstruction of law enforcement officer, that particular charge will be dismissed or null pros. Is that your understanding of the terms of the negotiated plea?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that as there are multiple charges to which you, excuse me, I'll strike that. Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Your Honor, also, the state would like to make a modification to the negotiated plea terms. The provision that says that defendant must be evaluated for mental health treatment within 60 days of guilty plea and complete treatment if needed. The state would like to strike that provision of the probation requirement unless defense opposes.
No, we don't oppose. She's already had an evaluation, and that's the medicine that she's on now. So she's undergoing treatment.
Okay, all right. Thank you. All right.
So you're striking all the requirements in the mental health.
Well, since she's already had it, no need to strike it.
Well, in that case, wouldn't it make more sense to strike it if she's already done what she needs to do?
Yes. You're right.
I feel like I'm causing confusion here, but what?
I think what we came down on is we're going to strike the part about needing mental health, getting mental health evaluation and treatment because she has already received the evaluation and she's on treatment.
Okay.
Okay. Thank you. Are you currently on probation or parole?
No.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter this guilty plea because you are in fact guilty?
Yes.
As to indictment number 22 SC 181924, how do you plead to the sole count of disorderly conduct in the same indictment?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, I understand.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? Yes. Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, I understand.
At this time, the state will provide a factual basis for the plea unless the defense is willing to stipulate to the factual basis, since this is a misdemeanor plea.
Yes, we're willing to stipulate.
I'll agree to this, to stipulate. Go ahead.
Okay, thank you, Your Honor. The state will provide this court the defendant's criminal history, just one moment. The computer is taking a little long here. Okay, Your Honor, pursuant to a GCIC that was pulled in May of this year, the defendant's only cycle of arrest in this in Georgia is the arrest that is at issue. Does the defendant wish to be treated as a first offender?
No.
Nothing further from the state, Your Honor.
Okay, Mr. Hornsby Wilson.
As ADA Clark stated, this is Ms. Rogers' first arrest, and I imagine it'll be her last arrest. This is an unfortunate incident that happens, but she's here to take responsibility for her actions. She has done.
Hopefully it'll be your last.
Well, hopefully.
Saving that first offender, you know.
That's all I can do is hope in this case.
Yeah.
But after speaking with her a little bit, I imagine that this will be her last time. We just ask that you accept this negotiated plea in this case.
Okay. All right, Ms. Rogers, do you understand the nature of the charge against you?
Yes.
You have just heard from ADA Clark explain all the rights you give up by his guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
Do you understand the court is not bound by the recommendation of the plea agreement, and I can sentence you as I deem appropriate?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
Mr. Hornsby Wilson, are you satisfied that your client is competent and understanding the plea is voluntary and there's sufficient factual basis for ending the plea?
Yes.
I find that there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. We'll accept your guilty plea and sentence you to the recommended sentence as follows, which is no pros counts 1 and 3, and then which leaves count 2. The simple battery gets reduced to disorderly conduct. You have 12 months probation. You'll be allowed to phone report. They'll waive the probation fees. And you'll have a behavioral incentive date of 6 months, providing that you comply with the terms of your probation. Is there anything else?
No, Your Honor.
Ms. Clark?
Nothing from the state, just wish the defendant well, Your Honor.
Okay, you are excused.
Thank you. Y'all have a good day.
Will misdemeanor probation come up here, or is there? Oh,
Sure.
sure. Your Honor, that concludes my business. May I be excused?
You're excused. What one you want to do next, Kathy? This one? All right, let's do Mohammed. That's the partner case with it. Okay, this is 22 SC 181924 Shima Mohammed, who is present in the courtroom with her attorney, Ms. Tanya Jones. And we have Christina Clark with the Fulton DA's office on Zoom. Ms. Clark, you have a negotiated plea to present?
Yes, Your Honor.
All right, go ahead.
And
Oh.
before she starts, I just want to let Ms. Clark know that this is a Alfred plea.
Okay.
Okay. Go ahead, Ms. Clark.
All right. Yes, Your Honor. Give me one moment because I want to go ahead and pull up the defendant's criminal history, Your Honor. So. Okay, thank you for your patience, Your Honor. Defendant Mohammed, please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. Please state and spell your true, correct, and legal name.
Shima Muhammad, SHIMAMUHAMMAD.
Are you at this time taking or under the influence of any medication, drugs, or alcohol?
No, ma'am.
How old are you?
25.
What's the highest level of education or the last grade you completed?
High school, 12th grade.
Where did you attend high school?
I graduated from Wheeler High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, willful obstruction of law enforcement officers by use of threats or violence, felony. Count 2, simple battery against police officer or detention officer. Count 3, obstruction of law enforcement officer. And count 4, reckless driving.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes.
I didn't hear you.
Yes, ma'am.
And did you understand the waiver of rights form as explained to you by your attorney?
Yes, ma'am.
And is it your decision to waive your rights today?
Yes, ma'am.
And did you sign the waiver of rights form with your attorney?
Yes.
And did you have an opportunity to review the indictment in this case?
Yes, ma'am.
And did you sign the indictment in this case where it indicates that there is a plea of guilty?
Yes, ma'am.
Your Honor, the state provides express permission to this court to sign my name on the indictment.
Okay.
And upon my signature, Your Honor, I ask that these documents be entered into the record.
So moved.
Thank you, Your Honor. Have you had enough time to speak with your attorney about all of the charges within the indictment against you, including the facts and circumstances relating to the charges?
Yes, ma'am.
Would you like more time to discuss the case with your attorney, Ms. Jones?
No, ma'am.
Are you satisfied with your attorney's services?
No.
I'm sorry.
No, ma'am.
Okay, Your Honor, would you like to take over? The defendant says they're not satisfied with the services.
Ms. Mohammed, you're not satisfied with the services of your attorney?
No, sir.
Well, I don't know how I can go forward with this plea at this moment then. Do you want to have an opportunity to speak with each other and then come back to this?
I mean, I thought it was just a question. I mean, I'm not satisfied. I mean, I thought it was just.
Well, I mean, it's the question, we're not just wasting time. I mean, the question is there for a reason and it has meaning. And if you're telling me you're not satisfied with the services of your attorney, I'm not sure I can go forward with this plea. I would suggest that I'm going to step out for 5 minutes and you talk with your attorney. And if you're still not satisfied, we'll have to go a different route. Okay. All right.
Yes. For the Brax, yeah, I did. Thank you so much. Yep. And hopefully it's not a mess in jail. No.
It will.
That was fun last Friday. Nope.
I think so.
No, I gotta scan them in.
Yeah.
Oh, you know?
Come to order, remain seated.
Okay. So we were on the question of whether you were satisfied with your attorney. I mean, we can discuss this further if you want.
Nah, that's cool.
Are you satisfied with her or? Okay, I mean, has she informed you of the rights you've given up?
Yes.
And she's informed you of the maximum sentences on the indicted charges, not the ones that are being reduced, and she's done that?
No.
She's not informed you.
We did go over the fact that the willful obstruction carries up to 5 years and the misdemeanors are 12 months, and that she's getting a 2-year probated sentence.
Okay,
Nah, no.
now you know.
Right.
All right. And so you're taking this plea voluntarily.
Yes, sir.
Okay. I mean, because I look, I can give you two choices. You don't have to like your attorney. But I do want to make sure that you were adequately informed on the rights you're waiving, that you've been adequately informed on the maximum charges, that you've been adequately informed on the sentence, the stipulated sentence, and that you are voluntarily taking this plea. Is that all correct?
Yes, sir.
Okay, because if you don't feel that way, we can not go forward with the plea and we can put you on a trial counter. Would you like to go forward with this plea?
If I wasn't to, you said you put it back on.
You got to speak up.
I'm sorry. If I wasn't to take the plea today, so you say you would put me back on the calendar for trial, but would I have to necessarily take it to trial? Would I have another chance to?
No.
So this is the final plea? is what you're saying?
Yes. I'm not going to play games that way where you get to just every time.
No, I'm just saying. As
No, you've
far-
got a choice. I just want to make sure it's voluntary. You've got a plea on the table. If not, we'll keep this on the trial calendar. I haven't gone over the, I can't remember now. And have you gone in your colloquy? You haven't gone through the maximums yet, have you, Ms. Clark?
No, Your Honor, I've not.
Okay, so you'll hear those maximums in a little bit, but I mean, if you want to, I mean, we can go on a trial calendar, and there's probably a pretty good chance it'll go to a trial the way things are going.
I'll just take the plea.
Okay. All right. Go ahead, Ms. Clark.
Are you satisfied with your attorney services?
Yeah.
I didn't hear you.
Yes.
Attorney Jones, do you waive a formal reading of the indictment for purposes of this plea?
We do.
Do you waive any and all defects in the indictment for purposes of this plea?
We do.
Your Honor, the state is unaware of any outstanding warrants related to the charges within this indictment. Defendant Mohammed, do you remember being arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
I'll provide
Yes,
those.
ma'am.
Speak up, yeah.
Okay. The willful obstruction of law enforcement officer felony charge carries with it up to a 5-year sentence in prison. Simple battery against a police officer carries up to 1 to 12 months in jail. Obstruction of law enforcement officer carries 1 day to 12 months in jail, and reckless driving carries 1 day to 12 months in jail. Do you understand that today you're entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For
Yes,
count
ma'am.
1, willful obstruction of law enforcement officer felony, the state's recommendation is 2 years probation. For simple battery against a police officer, the state's recommendation is 12 months probation, sentence to run concurrent with count 1. Count 3 is obstruction of law enforcement officer. The sentence recommendation is 12 months probation, sentence to run concurrent with count 1. And the 4th charge, reckless driving, the state's recommendation is 12 months probation, sentence to run concurrent with count 1. Is that your understanding of the negotiated terms of the plea?
Yes, ma'am.
Do you understand, Defendant Mohammed, that this court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge in the indictment?
Yes.
Do you understand that as there are multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively, meaning one or after the other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole?
Yes, ma'am.
Did you say yes? Okay.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years.
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
I didn't hear you.
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
It's my understanding this is an offer plea, so I'm going to read the questions related to offered, unless that's changed, PD Jones.
No, it's still an offered plea.
Okay. Are you pleading guilty, Defendant Mohammed, because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
As to indictment number 22 SC 181924, how do you plead to the felony charge of willful obstruction of law enforcement officer by use of threats or violence?
Guilty.
For count 2, simple battery against a police officer, how do you plead?
Guilty.
How do you plead to the charge of obstruction of law enforcement officer?
Guilty.
I didn't hear you.
Guilty.
How do you plead to the charge of reckless driving?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, that even after you are off probation, you can never carry a handgun or possess a handgun?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the offered plea in this case. On July 17th, 2021, Fulton police officers conducted a traffic stop after observing a gray Toyota Scion entering the roadway from the Budgetel Inn and Suites located at 4120 Fulton Industrial Boulevard, Southwest Atlanta, Georgia, Fulton County. The car failed to yield to oncoming traffic, almost causing an accident. After approaching the window to speak to the occupants of the vehicle, the passenger, later identified as Alyssa Rogers, became aggressive and hostile toward the officer. The driver, identified as the defendant, Shima Mohammed, started to yell at the officer using abusive language and racial slurs. Ms. Mohammed refused to hand over her license, registration, and insurance, and refused to roll down the window or exit the vehicle. While trying to get Ms. Mohammed to comply, Ms. Rogers exited the passenger side and approached the officer in an aggressive manner. The officer drew his taser with one hand and tried to pull Ms. Mohammed from the vehicle with his other hand. Additional officers arrived on scene from backup. Both women continued to resist arrest until they were tased by the officers. The state will provide this court an overview of the defendant's criminal history. The defendant has a total of 9 cycles of arrest. She has in Cobb County, she has a misdemeanor conviction in 2017 for battery, family violence in Cobb County. In 2017, she has a misdemeanor arrest for obstruction of law enforcement officer in Cobb County. In 2019, she has a misdemeanor conviction for possession of marijuana less than an ounce in Cobb County. In 2020, the defendant was convicted under first offender for aggravated assault, battery, and cruelty to children in the 3rd degree. Nothing further from the state, Your Honor.
Hey, Ms. Jones.
Thank you, Your Honor. As you can tell, Ms. Muhammad is still pretty upset about this situation. She believes that she was pulled over with no probable cause or reasonable suspicion. Your Honor, I have watched that video. Ms. Muhammad has also watched the body cam as well. It is noted that there is definitely some words being exchanged. Ms. Muhammad, who was scared to get out of the car, refused. She was dragged out of the car and at some point was tased, I believe 5 times, Your Honor. And so she's still very, very upset about this situation, but she is wanting to put this incident behind her. In addition, it's my understanding that Cobb County has revoked her first offender status based on this new charge here in Fulton County, which obviously makes her upset that she lost that. And so she is here, but she's here to take responsibility, Your Honor. So we just respectfully request, I just also wanted to add, I think one of the reasons why she's also not happy with my services is because I couldn't get that count 1 willful obstruction down to a misdemeanor. I did speak with the state in regard to that. And their reasoning is because she had at least two prior hindering or obstruction charges. So they weren't going to be able to reduce that to a felony. She's just in a little bit different spot than her co-defendant, Ms. Rogers, because my client's got a few more cycles of arrest. Thank you.
Okay. Well, I want to belabor it. Of course, that's the way negotiations work from both sides. I mean, this is what they've settled on, but I do want to make sure one more time that this is all freely and voluntarily given on your behalf, Ms. Muhammad. So you heard ADA Clark mention on the charges on count 1, there's a maximum of 5 years, and the other 3 counts, there's a maximum of 12 months. And so if we went to trial with your case, and if you were convicted, you could be facing potentially a maximum of that amount. Instead, you've got what amounts to a total of 2 years probation in front of you today as a plea. So I do want to make sure that you're freely accepting this plea agreement and you want to go forward with it. Okay. All right. So, Ms. Muhammad, do you understand the nature of the charges against you?
Yes, sir.
You've just heard the Assistant District Attorney Clark explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate? Although you are not admitting guilt, you have decided that it is in your best interest to plead guilty because at trial, the evidence against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charges against you?
Yes, sir.
Ms. Jones, you satisfied that your client is competent in understanding that the plea is voluntary and there's sufficient factual basis for entering the plea?
I do.
I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence as follows, which is count 1, 2 years probation, count 2, 12 months probation concurrent, count 3, 12 months probation concurrent, and count 4, 12 months probation concurrent. Is there anything else?
Not
Your
from the
Honor.
def-
Your Honor,
Yes.
from the state, Ms. Mohammed, I just wanted to let you know that PD Jones, Ms. Jones, your attorney, she did, in trying to advocate on your behalf, all out really, begged me to take away that felony charge. However, it was basically my decision. I decided to, based on your prior history of violence, that, I guess dismissing that charge or pleading it down to a misdemeanor was not going to. So I don't want you to leave here thinking that Ms. Jones did not advocate and try her best to get rid of that charge on your behalf.
Is there anything else?
For what it's worth.
Okay, you're excused.
She also has a warrant, Your Honor.
Oh, okay. I was, thank you for. That's from Cobb,
Yes,
I'm
from
assuming.
Cobb.
Okay. All right. All right. What do you want to do next, Kathy?
Okay, let's go ahead and do this.
All right. We'll do Miss Bigby. Which position is Bigby? Okay, so this is 22 SC 185020. Priscilla Bigby, who's present in the courtroom with her attorney, Mr. Clark. And we have Miss Clark, Christina Clark, with the district attorney's office appearing by Zoom. Pardon me? Are you able to go forward with this right now, Miss Clark?
Yeah, yes, Your Honor. I'm sorry, the system cut out for whatever reason.
No, that's all right.
Yes,
Ms.
I am.
Meyer was looking out for you, making sure I'd given you enough time to look it up. So,
Okay,
all
all right.
right. So we are on Miss Bigby, and you have a negotiated plea to present, correct?
Yes, Your Honor.
Okay, go ahead, Ms. Clark.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You can put your hand down. Please state and spell your true, correct, and legal name.
Priscilla Bigby, Priscilla, Bigby, Bigby.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you've not taken or been given today?
No.
How old are you?
36.
What's the highest level of education or the last grade you completed?
Some colleges.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offense? One count of cruelty to children in the second degree, which is going to be reduced to cruelty to children in the third degree misdemeanor.
I thought it was going to be reduced to reckless conduct. Is that?
Okay. Okay, sorry, hold on. Give me one moment.
Yes. I had an email from Ms. Charles on May 5th saying that it was going to be to reckless conduct.
Okay, yeah, and I'm sure that that's very true. I just wanted to, she has notes that she sent me, and I'm gonna go to the notes in Odyssey, in our system. And so it'll have the full context of that plea. And 1 second. Okay, so what I have here is she has reckless conduct, 12 months probation, parenting class, must testify truthfully at trial and make Jaquire available to testify and meet with us, provided she's willing to make a proffer about what she has seen and heard regarding the abuse of the victim in this case. Is that what you have?
That was the offer, and it's further discussed with Ms. Charles that this was going to be a first offender plea and it was going to terminate after she provided proof of the parenting class.
Okay. Do you have PD Clark? Can you forward me the email that the communication that you had with, can we go off the record for a moment? I'm sorry.
Sure.
Your Honor. I just want to make sure that I have the terms that were negotiated. So could you forward me the email?
Yeah, and I think those last terms were something that I discussed with Ms. Charles. So they're not reflected in the email that was subsequent to that, but I'll forward you the email that I had.
Okay.
And I just sent it.
Okay, because she doesn't have the early termination part in here.
And I know it's not the easiest thing to do with Miss Charles out of pocket right now, so.
And I had discussed, I know you're looking, Ms. Clark, I had discussed with Ms. Charles this last week too, but should have gotten it reduced to writing those last final terms.
Right. And it's not that it's not that I definitely know that but because it is a special unit and it's not my case, I have to, every term or provision, I have to have it in writing. So I'm trying to see if I can email her real quick, possibly.
All right, let me take a 5-minute break.
Yes.
Call me back, Ms. Robinson, when I need to come back.
Judge,
out.
can we take the other pleas? I have two pleas as well.
Pardon me?
That'd be great, that's it.
Okay.
And Your Honor, the only issue I'm gonna have is we're gonna run into the time that Ms. Beebe needs to go pick up her children. It's about 1:15 right now. If we
All right, we'll take a 5-minute case and we're gonna roll. We're gonna stay with Big B then. Okay. 5-minute break.
88 Clark, can you check your chat, please?
Yes.
Maybe Miss Iqbal can help you track down the TV folks.
Oh, that would be a good point. Okay.
Okay, I'm calling her now.
Yeah, I have her number.
Okay.
All right.
I did. I gotta do what I gotta do.
Miss Clark, can you check your chat? I just sent you a message.
I just sent it to you.
Okay, thank you. PD Clark, and you said that it was basically after the parenting class, you could terminate.
Yeah, after
Probation.
she'd show proof of that. Yeah.
Okay, all right. I think. I bring us in. PD Clark. Hey, I just called Laura McCauley
Okay,
and she said it's okay.
that's okay.
Yeah.
All right, so we're good to
Yeah,
go.
but
All right.
hey, just know that if this were my case, or even if this was just a complex case, trial division case, I would have just went ahead and went with it, but.
I gotcha.
Yeah.
I gotcha. I
Yeah.
appreciate it. Thank you.
Mhm.
Sounds like we're ready. Yeah.
Court come to order, remain seated.
All right, are we on the same page on Bigby now?
We are, Your Honor.
Yes, Your Honor, I actually called Deputy McCauley.
Okay, all right, we'll go ahead, Ms. Clark.
All right, thank you. Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes.
And is it your decision to waive your rights today?
Yes.
And did you sign the waiver of rights form
Yes.
that was provided to you by your attorney?
Yes, I did.
And did you have opportunity to review the indictment with your attorney?
Yes.
And you did sign the indictment where it actually enters a plea of guilty on that indictment?
Yes.
Your Honor, the state provides express permission for you to sign on my behalf. And after doing so, Your Honor, we ask that that the waiver of rights form and the indictment be entered into the record.
So moved.
Defendant Bigby, have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the
Yes.
facts and circumstances relating to these charges?
Yes.
Would you like more time to discuss the case with your attorney?
No.
Are you satisfied with your attorney's services?
Yes.
Attorney Clark, do you waive a formal reading of the indictment for purposes of this plea?
We do.
Do you waive any and all defects in the indictment for purposes of this plea?
We do.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Defendant Bigby, do you remember having been arrested on this charge?
Yes.
Has your attorney advised you of the minimum and maximum sentence for the reckless conduct charge you're pleading guilty today?
Yes.
The state will provide that for reckless conduct, the minimum is 1 day in jail, the max is 12 months in jail.
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? The state will recommend reducing or amending the charge cruelty to children in the second degree to the charge of reckless conduct. The state's recommendation is 12 months probation, a parenting class must be completed. The defendant agrees that she will testify truthfully at trial and make Jaquire, which is spelled Jaquare, available to testify and meet with the state, provided she is willing to make a proffer about what she has seen and heard regarding the abuse of the victim in this case. And defendant's probation will be subject to termination upon showing proof that a parenting class has been completed.
Is that your understanding?
Oh, yes.
Can you one more time go over testify truthfully at trial and then make, I didn't get the spelling available in the proffer.
Jaquire is Jaquare.
And what is she doing as well? She will, if
Available.
requested, she'll make a proffer describing
Yeah.
what she saw.
Yeah, providing what she's seen and heard regarding the abuse of the victim in this case, and she will make herself available to testify and meet with the state.
Okay.
And upon proof of completion of a parenting class, her probation will be able to terminate immediately.
Go ahead.
Okay. Is that your understanding, Ms.
Yes.
Bigby? Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Special conditions in this case will be completion of a parenting class and to testify truthfully at trial and to make Jaquire available to testify, and if a proffer is needed.
Yes. And it's Jaquari.
Jaquari, I'm so sorry. My apologies.
No, you're
But
great.
is the spelling right, Ms. Bigby?
Yes, the spelling is right.
Okay, Jaquari. Okay, I do apologize on the mispronunciation of that. Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Mr. Clark, did you say that she's seeking first offender?
She is.
Okay. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or no contest to a felony in the state of Georgia?
No,
Have you ever pled guilty to a felony in any other jurisdiction?
no,
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
no,
Has your lawyer explained the First Offender Act to you?
yes,
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked?
yes,
This means you understand that you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in the indictment.
yes. I understand.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes,
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
yes,
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
no,
Is it your decision to enter a guilty plea because you are in fact guilty?
And she would be entering it under Alford.
Okay. Are you pleading guilty because you have decided that it is in your best interest to do so?
yes,
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
yes,
As to indictment number 22 SC 185020, how do you plead to the sole count of reckless conduct?
okay, guilty by offer?
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes,
Do you understand that you only have a limited right to appeal this guilty plea conviction?
yes,
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
yes,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
yes,
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
yes,
At this time, the state will provide a factual basis for the misdemeanor plea in this case. Your Honor, unless the defense is willing to stipulate, but it is an Alford plea, so would this court like to hear the facts, even if the defense is willing to stipulate?
Yeah, but just make them brief. We will have some sort of factual basis. Doesn't need to be long though.
Yes, sir. This alleged case of child abuse was reported on August 28, 2017 to the Atlanta Police Department Special Victims Unit by email from Department of Family and Children Services. The Department of Family and Children Services first came in contact with the case on 15 August 2017 at High Spalding Children's Hospital at 35 Jesse Hill Jr. Drive, Southeast Atlanta, Georgia. in Fulton County. And due to the severity of the child's age and injuries, the child was transferred to Eagleson Children's Hospital at 1405 Clifton Road, Atlanta, Georgia, in Fulton County. Atlanta Police Department was not contacted by Hugh Spalding Children's Hospital regarding the findings of the case now being reported. Case manager went to Choa Elkston to make contact with Radamir Damar and Priscilla Bigby, the biological mother, on 8/16/2017. When the case manager arrived at the hospital, she was informed that the victim had been taken downstairs to complete a skeletal survey. The child in question had experienced a surgical hematoma. Registered nurse stated that when the biological mother spoke to the doctor, she had no explanation as to how the victim could have sustained the injury. The registered nurse stated that the doctor was Dr. Jenkins. There has not been any law enforcement involvement, only Department of Family and Children Services. Registered nurse reported that the biological mother, the defendant, has been appropriate with the victim since she has been there. The defendant stated that she disciplines Decory by taking away his TV or game privileges, or his behavior is extreme. She will give him a whooping. The defendant stated that she has a good relationship with her children, that when it comes to the victim, she is overprotective. Defendant denies any criminal, substance abuse, mental health, or domestic violence. Defendant stated that she has prior DFCS history, May 2017, stemming from Ternell Farley Decary's birth father, where a shooting and a gun involving a car took place. Defendant stated that Jacari attends T.H. Salter ES and is in the 5th grade. The victim, because of this incident or the hematoma, was admitted into the hospital. And an investigation ensued. The defendant, as the birth mother, was charged with cruelty to children in this case.
Okay. I guess you got a criminal history?
Yes, Your Honor. The defendant has a total of 6 cycles of arrest. The defendant does not have any felony convictions, Your Honor. Nothing further.
I would have to look again. Is that for Mr. DeMar or Miss Bigby? I don't believe Miss Bigby had any other arrests.
I don't have any.
Okay, hold on one moment. I do apologize for that. The criminal history, the GCIC is under here. Your Honor, I do not have GCIC for the defendant.
Okay. I could just state my place. She doesn't have any other arrests in her past, so.
Okay, well, go ahead, Mr. Clark.
Yes, Your Honor, we're asking the court to accept the negotiated agreement in this case. What I can provide some more context to the court. Obviously, this stemmed from an incident investigation into child abuse. I think coming out of that, a more complete picture that's I guess come up through investigation, and as this case has progressed, is that the young child, Radomir Damar, had suffered some head trauma that medical personnel did not believe was consistent with accident, that they believed was intentional. Through all the statements, I think what the evidence would ultimately point to is that this trauma had occurred potentially while he was in the custody of Mr. Damar. There was a separate accident that Radomir had suffered falling out of a car seat while he was in the custody of Miss Bigby, and I think that would more particularly form the basis of this reckless conduct charge. What I'll let the court know is Miss Bigby, as Radomir's sole legal custodian, was involved in defects dependency proceedings. She went through those completely through a final disposition where she was ultimately reunified with Radomir, and she's been had sole custody of Radomir for a number of years now. She has no prior convictions. She is working. What we would ask the court is to accept the plea as negotiated. We've already made Jaquari available to the state, and we did that at a prior court hearing. And in addition, Miss Bigby has completed a parenting class already, so we'll work on getting that proof to probation. By all accounts, Miss Bigby was a model participant in those defects proceedings. I've spoken with her attorney who represented her on that, and apparently nobody had anything negative to say. And she was 100% motivated to get through that case plan. We'd ask the court, in light of the fact that she has no history whatsoever, to accept this recommendation and sentence her to the negotiated plea.
Okay. Ms. Bigby, do you understand the nature of the charges against you?
Yes.
You just heard from ADA Clark explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
Do you understand the court is not bound by the recommendation or the plea agreement? I can sentence you as I deem appropriate.
Yes.
Although you are not admitting guilt, you have decided that it is in your best interest to plead guilty because at trial, the evidence presented against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charges against you?
Yes.
Mr. Clark, are you satisfied that your client is competent and understand the plea is voluntary and there's sufficient factual basis for entering the plea?
I am.
Okay, the court finds that you, Ms. Bigby, understand the nature of the crimes and consequences of this plea. There's a factual basis for the plea, and the defendant has knowingly, intelligently, and voluntarily entered this plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I am about to pose, which is I will agree to the recommended sentence, and that is it's one count. It's to reduce it to reckless conduct. It'll be 12 months probation. If you upon completion of prompt proof of completion of a parenting class, your probation will terminate, which you've represented already that you've taken that class and completed it. You are to testify truthfully at trial and also be available to the district attorney's office to meet with them regarding the other case. And you are also to make Jaquari available as well. And if you're requested, you'll provide a proffer regarding what you witnessed, the abuse that you witnessed. Is there anything else, Ms. Clark?
No, Your Honor.
Nothing from the defense, Your Honor.
Okay. You are excused, Ms. Bigby.
Okay. Thank you.
Your Honor, may I make one quick announcement?
Sure.
Position 28, 29, and 30, Michael King.
Okay.
He just left abruptly.
Really?
Yeah, I was talking to him. He got really, really mad and angry and left the courthouse. I just know he'll be on the 28th, but that's the only thing keeping me.
Where you did you have an offer from the district attorney's office or?
We were in negotiations, Your Honor, because the offer I had previously just involved 2 of his cases. So we were working on getting the 3rd one wrapped up. And during that time, he left angrily.
Ms. Clark?
Came out.
Your Honor, the state is fine with waiting until the 28th.
That's my inclination. We'll wait at the 28th, but reach out or whatever. You don't show up the 28th, and there's going to be a bench warrant and bond forfeiture.
Understood. Thank you.
Okay.
May I be
Thanks.
excused?
Yeah, you're excused.
It may be excused as well, Your Honor.
I'm sorry, Mr. King? Yeah.
Yeah, you're excused, Mr. Clark. All right, what do you want to do next, Kathy? What do we have next? They're Iqbal cases, I'm assuming. I know we got Mr. Zimmerman sitting there, that's anxious. And that came in before that? Okay, we'll just do them in order that came in. What position is Lumpkins on the calendar? Position 6? 7, all right. Joshua Lumpkins, we are gonna do, which is Mr. Zimmerman's case. Who has that with the state? Is that Iqbal?
Yes, Judge, that's me.
Okay,
And just to let you know, Your Honor, we're just going forward on count 3, the aggravated battery. We're no crossing count 1 and 2.
okay. All right. Okay, for the record, this is 22 SC 184333. We have Joshua Eugene Lumpkins present in the courtroom with his attorney, Mr. Barry Zimmerman. And we have Ms. Shama Iqbal, who is on Zoom. Ms. Iqbal, you've got a negotiated plea to present.
Yes, Your Honor, I do.
Okay, go ahead.
Okay, sir, please raise your right hand. Do you swear or affirm that any evidence or testimony you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. And Judge, this plea is going to be an offered plea under the First Offender Act.
That's correct, Your Honor.
Okay.
Okay, sir,
Thank
please
you.
state, spell your true, correct, and legal name.
Joshua Eugene Lumpkins,
Can you spell that, sir, for the record?
JOSHUALUMPKINS.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No,
Is there a medication you normally take that you have not taken today?
no,
How old are you, sir?
32,
And what's the highest level of education you've completed?
2 years of college.
And are you able to read and write and understand the English language?
Yes,
Do you understand that you've been charged with 2 counts of aggravated battery and 1 count of aggravated assault, and the state is moving forward with only 1 count of aggravated battery and no crossing the 1 count of aggravated assault and 1 count of aggravated battery?
yes, ma'am.
Okay, do you understand that you have the right to plead guilty or not guilty to these charges?
Yes,
And do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
yes, ma'am.
And sir, have you had an opportunity to review the waiver of rights form with your attorney?
Yes, ma'am.
And did you sign that waiver of rights form, sir?
Yes, ma'am.
And did you have an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you sign that indictment, sir?
Yes, ma'am.
Your Honor, at this time, the state moves to tender in the waiver of rights form and the indictment form into the record.
Okay, Ms. Iqbal, so there's no signature from you on the indictment form.
Apologies, Your Honor, you have my express permission to sign.
Okay, I'll sign it on your behalf and we'll move this into the record.
Thank you, Judge. I appreciate that. And sir, have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances related to these charges?
Yes, ma'am.
Would you like any more time to discuss this case with your lawyer?
No,
Are you satisfied with the services?
absolutely.
Counsel, do you waive formal reading of the indictment?
We do.
And counsel, do you waive any and all defects in the indictment, including any with respect to his name?
We do.
Okay. Sir, has your attorney advised you the minimum maximum sentence for the charge that you're pleading here today?
Yes,
Do you understand that the minimum is 1 year and the maximum is 20 years?
yes,
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means that the state and the defense jointly will recommend the following sentence to the court? As I previously stated, count 1 will be no prost, count 2 will be no prost, and count 3, the state's recommendation is 6 years of probation. Special conditions of probation include must complete a family violence
You had
intervention.
text me, sorry to interrupt, you had text me that it'd be 3 years. And I agreed.
I apologize. Are you okay? 3 years. Is that, I'm sorry, I think I got my cases mixed up. Okay, that's fine. So State's recommendation is 3 years of probation. Special conditions of probation: must complete a family violence intervention program and have no contact with the victim. Do you understand that, sir?
Yes, ma'am.
Do you understand that the court's not required to accept the state's recommendation, that the court has the right to sentence you in the maximum sentence on this charge?
Yes, ma'am.
Are you currently on probation or parole?
No.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit.
Yes, ma'am.
You understand that if you're on probation, you must follow all the special conditions of your probation.
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation for the balance of the sentence.
Yes, ma'am.
You understand that you're not allowed to possess or use a firearm while on probation.
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so will result in new criminal charges for which you could face a sentence between 1 to 10 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were to use a firearm in a crime, in the commission of a crime in the future, you could face up to a 15-year custodial sentence?
This is a first offender plea, so he'll
I
have. a first-
understand.
Okay,
I just have to go, I'm going to the first offender afterwards, but
okay.
if he is on first offender probation and he commits a
Right.
crime with firearm, he could face up to a 15-year custodial sentence. Do you understand that,
Correct.
sir?
Yes.
Okay. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo contendere to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, which means that you could be adjudicated guilty and re-sentenced up to the maximum sentence for the charge in the indictment?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Okay. And are you pleading this under North Carolina v. Alford?
Yes.
And you're pleading guilty because you've decided that's in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Okay. And so how do you plead, one moment, Your Honor. How do you plead to indictment number 22 SC 183? Oh, no, I'm sorry, wrong indictment, apologies.
Guilty under offer.
Yes, I just need to give you the, hold on one moment, sir. How do you plead to the charge of aggravated battery in indictment number 22 SC 184333?
Guilty under offer.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
And do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and you only have 4 years from today's date to file that petition? Do you understand that, sir?
Yes, ma'am.
Your Honor, how this case gone to trial, the state would be able to prove beyond a reasonable doubt that Mr. Lumpkins, the defendant, and Ms. Gunduz, Gunduz, were married at the time and lived together. And on May 17, 2019, officers responded to 867 Roswell Creek Lane in Roswell, Fulton County, and spoke with Miss Gunduz, and she advised officers that she was trying to leave. The defendant would not give her her car keys. They had gotten an argument, and at that time, the defendant grabbed her and punched her in the face near her right eye, causing her to temporarily lose consciousness. And there was a laceration on the eye, Your Honor. Yes, and so the defendant was not, I believe, not there at the scene. I'm sorry, he was there. I apologize. He was able to speak to officers, and he said that he didn't know what had happened. That is it, Your Honor. He has no felony convictions at all. We've spoken to the victim, and she's moved on, Your Honor.
All right, Mr. Zimmerman.
Thank you, Judge. Judge, we're obviously entering the plea today under Alford because Mr. Lumpkins has a little different version of that, but I won't bore the court with that. Mr. Lumpkins, 32 years old, as you heard, because of this event, this arrest, and this indictment, he's been unable to secure a job. He has looked countless places. He lives with his parents. His mother is here today, sitting in the second row. As a result of that, Judge, I'm going to ask if Your Honor would consider signing an order, and I've prepared it. I don't have it in writing, but I have it on my iPad, and I can email it to Your Honor immediately. An order under OCGA section 42-8-62.1, which would seal the record now while he's on the first offender probation. That will allow him. He's had offers before, and then the minute they check his history and see their arrest, they take away their offer. That should allow him to get and maintain gainful employment. And it would be appropriate in this case. Excuse me. So, and like I say, I've already prepared that, and the district attorney, assistant district attorney, has no objection to that, Your Honor. She's just leaving that to Your Honor. The other thing I'd ask Your Honor, I don't know if you need to put it in the order or not. Under OCGA section 42-8-34.1, of course, it says, even though this is a 3-year sentence, it says that he can be supervised for no more than 2 years. I find in various and sundry jurisdictions that the probation departments don't automatically go to non-supervised after that 2-year period has expired. So I'd ask Your Honor to put as part of the order that it will become, after 2 years, it will become unsupervised or non-supervised for the last year. Other than those requests, I respectfully request Your Honor accept the negotiated plea.
And Judge, just the one caveat, that's fine as long as he's completed all of the special conditions, which is to complete the family violence intervention program.
Absolutely. I agree with that 100% as well. And I think the statute would also say that.
Okay. So it sounds like you've gone over the First Offender Act with Mr. Lumpkins. Obviously, he's 32 years old. He has no felonies. So I want to believe this is an aberration, whatever occurred. And so he understands the pros and the cons. And of course, the con is that, and ADA Iqbal's gone over that as well, that if you do mess up while you're on probation, then we can come back and sentence you to the maximum on the aggravated battery charge. So you understand that, correct?
Yes, Your Honor.
But of course, the advantages, and Mr. Zimmerman, I'll agree to seal it, especially again, given the fact you're 32 years old with no prior felonies, that for all intents and purposes, you complete this successfully, you won't have the criminal record anymore. So with that being said, I have a few questions for you. Mr. Lumpkins, do you understand the nature of the charges against you?
Yes.
You have just heard from ADA Iqbal explain all the rights you give up by this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
You understand that the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate.
Yes.
Although you are not admitting guilt, you decided it is in your best interest to plead guilty because at trial, the evidence presented against you may be strong. You freely and voluntarily enter your plea of guilty to the charges against you.
Yes, Your Honor.
Mr. Zimmerman, are you satisfied your client is competent and understand the plea is voluntary and there's sufficient factual basis for entering the plea?
Absolutely, Your Honor.
Okay, Mr. Lumpkins, the court finds that you understand the nature of the crimes and the consequence of this plea. There is a factual basis for the plea, and the defendant has knowingly, intelligently, and voluntarily entered this plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that his plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which, as I said, I will agree to the recommended agreement, which is count 1 and 2 to be null pros. Count 3 will be 3 years of probation. The defendant must complete a family violence intervention course and have no contact with the victim. I will agree to sign your order, Mr. Zimmerman, to seal it. And as you've quoted the statute, it can the probation will go to unsupervised after 2 years, providing that he has complied with the conditions of completing the family violence intervention course. And of course, no contact with the victim, but you contact the victim, that'll bring you in here for other reasons. So,
Right.
anything else?
Judge, you want me to email that to Your Honor or to your clerk, right?
Yeah. Why don't you email it to Ms. Robinson and she can forward it to me and I'll print it out and sign it. Anything
And
else?
please include me or sir, please include me on the email as well.
Yeah, good,
Absolutely.
good. Always a good idea.
I will do that for sure. Now,
Nothing else from the state, Judge.
say again?
I said nothing else from the state.
Okay.
And will he meet with probation now? Is there an intake? There you are.
Right here.
Okay. Judge, that'll complete our business other than me emailing it, him seeing probation. May we be excused after that?
You are excused.
Thank you, Judge. Let's see where she wants you to say.
What's the next case we need to do?
What do you want him to?
Right outside.
Okay.
All right. Where is Deontay Atkins?
Right here, Judge.
What position are y'all?
We are number 4.
All right.
Sitting so long, I've gotten.
Well, I hope it was worth the wait, There's worse things you could have been doing. I'm trying to think, but what?
Wow.
That's a privilege. That's a privilege. What are you talking about?
Bunch of stand-ups in this room.
All right. Position 4, 22 SC 183-767. Deontay Atkins, who is present with his attorney, Mr. Kish. And we have Ms. Iqbal representing the district attorney's office on Zoom. Ms. Iqbal, you have a negotiated plea to present?
Yes, Judge.
Go ahead.
And just to make the record clear, this will be an offered plea.
Okay, this is going to be
Yes,
an
Judge.
offered plea.
And Judge, just to also put on the record, the paperwork, I believe my signature is not on there. I would definitely give permission for the court to sign on my behalf.
Okay.
Okay.
I will sign on your behalf as you're doing the negotiated plea.
Thank you, sir. Mr. Atkins, can you please raise your right hand? Do you swear or affirm that any evidence or testimony you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand and please speak up. I'm having a hard time hearing you. Please state and spell your true, correct, and legal name.
Deontay Atkins, DeonteAtkins.
And sir, at this time, are you taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication you normally take that you have not taken today?
No, ma'am.
How old are you, sir?
Today I'm 37.
And what's the highest level of education you've completed?
Bachelor's degree.
Are you able to read and write and understand the English language?
I am.
And do you understand that you're charged with the following offenses: 2 counts of aggravated assault and 1 count of false imprisonment?
I am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
I understand.
And do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
I understand.
And sir, have you had an opportunity to review the waiver of rights form with your attorney?
I have.
And did you sign the waiver of rights form?
I did.
And have you had an opportunity to review the indictment with your attorney?
I have.
And did you sign the indictment?
I did.
Your Honor, at this time, the state moves to, excuse me, tender the waiver of rights form and the indictment form into the record.
Okay, so moved.
And sir, have you had enough time to speak with your lawyer about all the charges in this indictment, including any of the facts and circumstances related to these charges?
I have.
Would you like any more time to discuss this case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
I am.
And counsel, do you waive formal reading of the indictment?
We do.
And do you waive any and all defects in the indictment, including any with respect to his name?
Yes.
And sir, has your attorney advised you the minimum maximum sentence for each charge that you're pleading here today?
Yes.
Understand aggravated assault, the minimum is 1 year, the maximum is 20. False imprisonment, the minimum is 1 year, the maximum is 10.
I understand.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state and the defense jointly recommend the following sentence to the court? For count 1, it's a 5 years to serve 1 commuted time served, balance on probation, special conditions of probation. Is that correct?
No, ma'am. We've had 2 phone conversations today.
I'm so sorry. I've had like.
I know
15
you have. I know
conversations.
you've been very busy.
What did we end up deciding?
We ended up deciding on time served with 3 years probation.
That's correct. That's why I wanted 3 years.
Yes,
Okay.
ma'am.
Okay, that is correct. I apologize, Your Honor. Strike the first part. It's 3 years of probation, Your Honor, for the count 1. Special conditions of probation is a family violence intervention program and to have no contact with the victim. Count 2 would also be 3 years of probation to run concurrent with count 1, and count 3 is also 3 years of probation to run concurrent with count 1. Sir, do you understand that's what the state is recommending to the court?
I understand.
Do you understand the court is not required to accept the state's recommendation, that the court has the right to sentence you to the maximum sentence on each charge and even run those consecutively, meaning one after another?
I understand.
Are you currently on probation or parole?
I am not.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
I understand.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
I understand.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
I understand.
And do you understand that you're not allowed to possess or use a firearm while on probation?
I understand.
And are you a United States citizen, sir?
I am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
I understand.
Do you understand doing so will result in new criminal charges, which you could face a sentence between 1 to 10 years?
I understand.
Do you understand that by pleading guilty to a felony, you may not use a firearm in a crime in the future?
I understand.
You understand that if you were to use a firearm in a commission of a crime in the future, you could face up to a 15-year custodial sentence.
I understand.
Do you understand that by entering a plea of guilty, you're waiving any and all defenses, including any mental health defenses?
I understand.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial?
I understand.
Is it your decision to waive these rights and enter a guilty plea today?
It is.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
And are you entering this guilty plea via North Carolina via Alfred?
Yes, ma'am.
And you're pleading under Alfred because you decided it's in your best interest to do so?
Yes, ma'am.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
I understand.
Okay. And sir, as to indictment number 22 SC 183767, how do you plead to the 2 counts of aggravated assault and 1 count of false imprisonment?
Guilty under Alfred.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It is.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
It is. I do.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
I do.
And you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and you only have 4 years from today's date to file that petition.
I understand.
Okay. Your Honor, had this case gone to trial, the state would be able to prove beyond a reasonable doubt that on March 25th, 2020, officers responded to 600 Phipps Northeast Boulevard, apartment 2516, which is in Atlanta, Fulton County, and met with the victim. Her name is Kirsten Applebaum, Kiersten, Applebaum, Applebaum. At the time, the defendant and Ms. Applebaum had lived together and been in an intimate relationship. Officer who lived at the location, he heard Miss Applebaum screaming, and that's when he approached the apartment and made contact with her. And at that point, she told officers, at first she told officers that nothing, she just wanted him to leave. But once the officer was able to separate the two parties, she was able to tell them that he put his hands around her neck and began to strangle her. And then when she started screaming, he took a pillow and placed it over her face in an attempt to stop her from screaming. She even wanted to leave at one point, and he prevented her from leaving, Your Honor. And there was a witness, but all he was able to do is see her come out of the apartment with an unbuttoned top. He didn't see any of the incident of any sort of that, Your Honor. Another issue, and the reason, Your Honor, another issue is this case is, and the reason we're offering the 3 years of probation is the officer who heard her screaming is also officer involved in the shooting that occurred in Wendy's. That's another thing, Your Honor. This defendant does have some criminal history. It is pretty old, Your Honor. I see at least 4 felony convictions, but the most recent one is from 2000, and the most earliest one is from 1995. They range from drug possession, Your Honor, possession of a firearm.
The defense and the defendant are looking very confused about these felony convictions here.
My client has one felony conviction from when he was 19 years old, and somebody talked him into pleading guilty to a felony as a 19-year-old when he had no prior offense. It's not even listed on the NCIC, but as an officer of the court, I felt obligated to inform the court of that. My client also was arrested for the Texas offense of evading by watercraft. I think that's the most recent arrest, and that was in 2019, which I think is the last time he was arrested.
Okay, Judge, then this must be a different.
I believe that could be a different,
Atkins.
different person. Yes, ma'am.
So I'll strike all that from the record, and I will, as an officer of the court, I will defer to you, sir, defense
Thank
counsel.
you. I appreciate that. Thank you.
Nothing further from the state, Your Honor.
What about, maybe I overlooked it. You have no contact with the victim in here as well?
Yes, Judge, absolutely no contact with Ms. Applebaum.
All right. Mr. Kish?
This is like so many situations where people shouldn't be together who are together, but they're no longer together, and each of them have moved on with their lives. Mr. Atkins, thankfully for him, I know that Ms. Applebaum is doing well in her career. He's doing well in his career, and he and his fiance who are here are going to have their first child together. He's also a single father. He's been raising his son on his own for most of his life. His son is now a junior in high school, is the lead of the Arabic program of all things in his school. He's done well. Again, this is an unfortunate incident. There's more than one side to it, but we think that under the circumstances, the parties have negotiated in good faith. We think this is a reasonable resolution.
What high school your son go to?
Jonesboro High, sir.
All right. How quickly can he do the family violence intervention program? I just want to put something down. I don't need you to tell me something that's going to be too quick, but
30 days, Judge.
All right.
To start it, right? It's a 28 weeks or 26 weeks. Something. Okay.
Sure. Yes, ma'am.
Okay, just want to make sure.
Okay. How long is the program?
I was under the understanding it's 28 weeks, Judge.
Okay.
I believe so, Judge. I hear sometimes 26 and then sometimes I hear 28, but it's in that realm.
All right. Mr. Akins, do you understand the nature of the charges against you?
I do.
You just heard ADA Iqbal explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
You understand that the court is not bound by the recommendation or the plea agreement. I can sentence you as I deem appropriate.
Yes, sir.
Although you are not admitting guilt, you've decided it is in your best interest to plead guilty because at trial, the evidence against you may be strong. You freely and voluntarily enter your plea of guilty to the charge against you.
Yes, sir.
Mr. Kish, are you satisfied that your client is competent and understand the plea is voluntary and there's sufficient factual basis for entering the plea?
I am.
I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I'll accept your guilty plea and sentence you to the recommended plea as follows, which is, let me pull this up here. Count one will be 3 years probation. He is to complete a family violence intervention program within 1 year and no contact with the victim. Count two will be 3 years probation concurrent, and count three will be 3 years probation concurrent. Is there anything else, Ms. Iqbal?
No, Your Honor, nothing else from the state.
Mr. Kish?
No, sir. Can we be excused?
You
after
are
we're done here?
excused.
Thank
You're
you, Judge.
excused. There's probation. You need to, okay.
Thank you, Judge.
Thank you, sir.
All right. All right, I have one more.
Judge, I think that concludes my business as well. I can jump back on. I've got to jump on to another Zoom. May
I
I
think
be
that
excused?
concludes, well, who has Bowen? Oh, okay, well, I think you're done, Ms. Iqbal.
Okay, thank you
Judge,
so
can I
much.
make a brief announcement? It's Renee.
Sure.
So I was gonna wait and see if I could visit with Miss Christinia Clark in a breakout on Roderick Davis. I'll just get to her directly, Judge, and we'll get back with Miss Robinson if we have some groundbreaking.
Well, maybe we can do it on the 28th.
Yes, sir. May I be excused?
You're excused.
Thank you so much. Thank you, Madam Prosecutor.
All right, Ms.
Both of you.
Iqbal, you're excused as well.
Renee,
thank-
I mean,
Thank you,
Miss Rockwell, before you go, I actually just got kicked out of Zoom and it popped me back on. So do you mind repeating what you just said? I do apologize.
Oh, so I was just waiting I didn't know if I had Miss Iqbal or you on Roderick Davis. I was waiting and Miss Iqbal said it's gonna actually be you to see if I could do a breakout room with you, but I know you've been rocking and rolling, so I'll just reach you directly. I think my client's phone might have died. And if we come up with something, we'll figure it out.
Okay,
That's what I asked the judge, if I could just do
I
it.
messaged you back on Zoom, but I guess
I-
it had said you had logged off.
Yeah, when I get logged off, I lost it, so I'll reach you directly.
Okay, all right.
Okay,
All right,
thank you so
all right.
much.
Hopefully we have something on the 28th.
Thank you, Judge.
Okay. All right, thanks. So we're gonna punt that at 20, we'll just leave them on the trial calendar. Okay, Mr. Clump. Last but not least, huh? Well, okay, so I see, how do you pronounce your client's last name?
Shisharan, I believe.
I see Mr. Shisharan.
Yes, Your Honor.
Okay, so this is 20 SC 174626, Bowen Shisharan, who is appearing by Zoom. His attorney, Mr. Clump, is in the courtroom with us, and Ms. Clark with the district attorney's office is appearing by Zoom. Mr. Shisharan, since you're appearing by Zoom and you're about to take a plea, I want to make sure you understand that if you have any questions, comments, concerns, thoughts, anything, interrupt us. Let us know you want to speak with your attorney privately, and we'll arrange for that to happen, okay?
Yes, Your Honor.
All right, do I have your permission to go forward with this by Zoom?
Yes, Your.
Okay, go ahead, Ms. Clark.
Yes, Your Honor. And before we get started, you do have my express permission to sign my name on the indictment, Your Honor.
All right, I'll sign that right now.
Thank you. And could you pronounce your name for me one more time, sir? Shisharan, is that correct?
Bowen Sipcharan.
Okay. Please raise your right hand.
Yes, ma'am.
Do you swear or affirm that any evidence or testimony that you shall give in this matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Okay. Please state and spell your true, correct, and legal name.
Bowen Sipcharan, BOWANSHIWCHARRAN, Sipcharan.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you've not taken or been given today?
No.
How old are you?
52.
What is the highest level of education or the last grade you completed?
9. 9th grade.
And where did you go to high school?
Guyana.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1, aggravated assault, and count 2, possession of knife during commission of a felony.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes.
And did you understand the waiver of rights form as explained to you by your attorney?
Yes.
And is it your decision to waive your rights today in this proceeding?
Yes.
And did you sign a form, the waiver of rights form, with your attorney?
Yes.
Did your attorney review the indictment with you in this case?
Yes.
And did you sign the indictment with a plea of guilty?
Yes.
Your Honor, at this time, the state moves to enter both the waiver of rights form signed by the defendant and the indictment signed by the defendant into the record.
So moved.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss the case with your attorney?
No.
Mr. Klump? I'm sorry?
No.
Okay. Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Klump, do you waive a formal reading of the indictment for purposes of this plea?
Yes.
Do you waive any and all defects in the indictment for purposes of this plea?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to the charges within this indictment. Defendant Shisharan, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading guilty today?
Yes.
The state will provide that information to you as well. For the crime of aggravated assault, the minimum is 1 year in prison. The max is 20 years in prison. For possession of knife during commission of a felony, the term is consecutive to the underlying felony, which would give 5 years, which 5 years in consecutive to whatever the underlying sentence is. Do you understand that today you are entering a negotiated plea of guilty, which means that the state and the defense will recommend the following? For count 1, aggravated assault, The state's recommendation is 6 years probation plus the special conditions of probation as set forth below. Count 2, possession of knife during commission of a felony. 5 years consecutive sentence is suspended. Special conditions of probation. Defendant is to complete a family violence intervention program, and he must complete that program within 18 months of the disposition of this case. But I heard today that it's actually 24 months. So the state is willing to alter that special condition and give the defendant until a total of 30 months to complete the family violence intervention program. Defendant must be evaluated for mental health and psychological evaluation within 60 days and complete all recommended treatment, including compliant with taking all medication as prescribed. With this plea, the defendant consents to a waiver of his health information to the state, limited for the sole purpose of verifying or confirming that he is completing the recommended mental health treatment and that he is compliant with all medications. Defendant is to have no contact with the victim, Salam Cordell. Defendant is to have no
Can you
violent
spell that?
contact.
Can you spell that?
Salam is S as in Sam, A as in Apple, L as in Larry, A as in Apple, A as in Apple, M as in Mary. Cordell is spelled C as in cat, O-R-D as in dog, E as in elephant, L as in Larry, L as in Larry. Okay. No violent contact with Indira, and that's spelled I-N, D as in dog, I as in ice cream, R as in rabbit, A as in apple, Shisharan. No drugs unless prescribed. Defendant is subject to random drug screens. Defendant must not possess any weapons or firearms. Is that your understanding of the terms of the negotiated plea you were expecting today?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yeah.
I didn't hear you, sir.
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively, meaning one after the other?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
No.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status?
Yes.
Do you understand that a conviction through a guilty plea will result in deportation in just the same way that a conviction at a trial would?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that by accepting this guilty plea, that you will be a convicted felon, and even after your probation ends, you will never be able to carry or possess a firearm?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 20 SC 174626, how do you plead to the charge of aggravated assault?
Guilty.
How do you plead to the second charge of possession of knife during commission of a felony?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the felony plea in this case. We'll try to be as brief as possible. If this matter had went to trial, the state would have been able to prove beyond a reasonable doubt that on January 23rd of 2020, at the incident location of 310 Windsor Way, Fairburn, Georgia, in Fulton County, officers responded to an assault and made contact with the victim, Cordell Salam. The victim, and Andrea Ciceron, the wife of the defendant. Ms. Ciceron stated that she was home with Salam, her fiance, when the defendant came home and demanded to know who Salam was. The defendant then woke up Salam, the victim, and demanded to know why he was in the house. A verbal altercation ensued, and the defendant walked into the kitchen, according to Ciceron, and Salam picked up a knife and charged at Salam. Salam picked up a chair to block the defendant and tried to grab the knife, resulting on cuts to Salam's hand. The defendant admitted that he picked up the knife and charged at Salam. The defendant was arrested and charged accordingly. The state will provide an overview of the defendant's criminal history. Defendant has a federal conviction for assault with intent to rob while armed. That was from March 8th of 1989. The arresting agency was in DC, which is a federal agency. Also, GCIC. The defendant has one cycle of arrest, Your Honor. The only arrest that he has is the arrest at issue in this case, Your Honor. Nothing further from the state.
Okay. Go ahead, I'm sorry.
Your Honor, it is a negotiated plea. We'd ask you to accept it. My client has appeared by Zoom a few times, and of course, he's appearing by Zoom today because he's suffering from some severe health issues. He's been in a nursing home in New York for over a year, maybe over 2 years at this point. So he did want to take responsibility and resolve this case, and we ask you to follow the recommendation.
Okay, Mr. Shisharan, do you understand the nature of the charges against you?
Yes, Your Honor.
You just heard from ADA Clark explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes.
You understand the court is not bound by the recommendation or the plea agreement. I can sentence you as I deem appropriate.
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
Mr. Klump, are you satisfied that your competent understanding that your client is competent and understand the plea is voluntary and there's sufficient factual basis for entering the plea?
Yes, Your Honor.
Okay, I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence, which is count 1, 6 years of probation. Count 2 is 5 years consecutive suspended with special conditions that defendant is required to complete a family violence intervention program within 30 months of today. Undergo a mental health evaluation and follow the recommendations, including remaining in compliance with any medication. He agrees to a health waiver, which will be limited to simply to ensuring that the client is complying with the mental health recommendations. He is to have no contact with the victim, which is Mr. Cordell, and no violent contact with Indira. Is it Indira Shishawan?
Yes, Your Honor.
No violent contact with her, and you are subject to random drug screenings and no weapons or firearms. Is there anything else?
Nothing from the state, Your Honor.
Your Honor, I would just ask, I can take that with probation, how he should get in contact with probation.
I'll come over and speak to him.
Okay.
If that's okay.
Yeah, that's fine. That's fine. All right, so Mr. Shishawan, hang on, and Ms. Colors is going to come over with probation and discuss how you are going to comply with probation.
Cover that with this.
Okay.
X out of that.
How are you, Mr. Shisharan? My name is Nelsia Colors with probation. First of all, I'd like to just let you know it's fine that you get your probation transferred to where you live, but I need that address. Would you be able to give me that?
Yes. What's the address here? 191-06.
1921-06.
No, 191-06.
Sorry. 191-06.
Hillside Avenue.
Hollis, no. Side Avenue.
Hillside Avenue, Hollis, New York.
Hollis?
Yeah.
Yeah, Hillside Avenue, Hollis, New York.
What's your zip?
11432.
Okay, is there a contact number that you can give me?
Yeah, 404
Yes,
853
yes.
9494.
Do you have an email address?
I can give you my daughter one.
Okay, what is it?
BRIANA.SHIWCHARRAN@gmail.com.
Okay, what I am going to do is I am going to send you some information as it relates to probation. And just to let you know, there is a $100 ICOTS fee, which is a fee that's needed to transfer your probation to New York. They will also use this email address to send you your intake packet, and you'll have to look at that information, sign it, and send it back. That will more than likely happen within the next 48 hours. What I would need from you, Mr. Shisharon, is I would need for you to send me a selfie of yourself behind in front of a light colored background, and you can send it to this number. Let me know when you're ready to take this number down.
Got it. And put it on my phone. Okay, I'm ready.
It is area code 404
404
576
576
4007.
4007.
Yes. And that should get your ball rolling, but someone will be in touch with you within the next 48 hours, okay?
Where do I send the picture to this number?
Yes, you can send the selfie. That's my number. It's just to go with his information that I'm about to put in our system.
Okay.
And if you have any questions, you can call me at that number as well, okay?
Okay, thank you.
All right, thank you. Thank you, Your Honor.
Okay, thank you. Anything else?
Your Honor, let Madam Probation know that I'm gonna be emailing her over a copy of the police report for the transfer to
All right.
New York.
Mr. Klump, you're excused.
Thank you, Judge.
Been a long day.
Hadn't been too bad. I've got everything wrapped up. I'm not out here much, but it was a very enjoyable experience, and I appreciate Ms. Robinson's email. It's very efficient.
Yeah. All right. Not often people associate us with enjoyables, so I'm glad you.
I mean, Gwinnett most of the time. Everyone's got, their pros and cons.
All right, all right.
Thanks, Judge.
All right, you're excused. Thank you. All right, Ms. Clark, thanks for your help, and we are adjourned.
Judge Eaton,
Yes.
call me. I had sent you an email. Please.
Okay.
All right.